of to obtain instruction regarding the nature of allegation made before the collector period. Regarding because the collector has passed the order on the Annex 1 for 66 soft. I have obtained instruction.
No, post the after stipulated period. Can you? And that too, this is functioning since last 30 years.
So that is, we have already delivered a judgment in this. That subsequent objection cannot be entertained. Your whole act is there, sir.
And section
How can you do it?
Section 41.
41.
That you have not kept in view. Section 41?
Yes.
What is the purport of section 41? He has indicated in his proviso. Yes.
Provided that no objection shall be ordinarily entertained for such continuing in an area for more than 3 years unless there are special reasons to be recorded in writing. Here there is no objection. There is no objection at all. To my knowledge, there is no objection.
One thing, school is set up after this or before.
That is very important.
On that
You do not know.
So that was the question we asked you.
That is the whole problem, sir. Please, whenever any file is assigned to you, I think you should read it, formulate a point, ask the officer to come and answer those points.
very hastily has prepared these person.
Sir, definitely not in the way it is done, sir. I tell you with all humility at my command, that augments the delay in the cases. Now the bar has come up, and I will be very critical in my deliberation.
Bar has come
up. One topic has been given on 14th. This is the topic.
It's a 14 that meeting.
Today is a Sunday. There is a topic. This is the topic.
Yes, we need to file an affidavit.
What affidavit you will file? Just tell me what affidavit. We will give you. No doubt about it. You have a right. But once the pure legal question comes on an unadmitted facts, on an admitted facts, then you'll have to answer the legal point. You can deal with the facts, but if the facts are undisputed.
So far this allegation part is concerned, page 2, paragraph 1. They have stated.
What?
Regarding allegations.
Sir, unilaterally you will take decision. Can you?
Cannot. Rule doesn't follow.
His function there. Article 19, Article 19(1)(g).
These are all the pure question of law. When you talk about paragraph 2 allegation, no, it's not an allegation. It's a point of law which he has taken. That can you do it in view of the provision of the law?
No, after that, for top date objection, last date of objection, we cannot enter.
How can the objection be entertained? So that's a legal point.
I think you have brought the statute book, the amendment, after his establishment.
No, we have decided a rule also.
Yes.
Section 41 say ordinarily it will not be entertained, but if the rule says that it will not be entertained at all, then what more? It does not offend the core value of the act. I think rule 33 or
33(2).
So
14 of judgment, paragraph 12.
No, we have not said anything. We have extracted the
Exactly.
the statutory provision only. There is no ambiguity in provision also. And you accept that rule 32, 33 will apply even for shifting.
Yes.
we have extended that.
Shifting, objection before renewal, everything.
Everything is to be done. And thereafter, when what to do, sir?
This is the instruction will people are.
What instructions, sir?
An application.
Also, he has
The
no
challenge,
jurisdiction.
the superintendent of
Yes,
excise,
he can't pass
is
an
he
order.
competent?
Superintendent is not
He
competent.
is not competent,
No.
then
Rule 53.
Rule?
Rule 53. That's not discussed in the earlier judgment of the Rashtra. Rule 53, sub-rule 5. No jurisdiction. Unless it is approved from the commissioner, collector will give the proposal. Superintendent straightway directs you strictly. That's all.
And it is stated at the bottom of the order, the by order of the collector.
How can the collector pass an order?
where is that?
Well, I do not know.
Annex 4.
Annexure 1.
Annexure
Annexure
1. We are not concerned with Annexure 4.
He is not saying that I am directed to issue.
That's it for license.
Annex 1 meter. Only superintendent of excise.
Huh?
Yes.
Annexure 1, he is not saying that I am directed to.
No, answer.
He has not written that.
That is Annex 1.
You have not verified the record.
Sir, that was in 1921. Sorry, 2021.
Transfer
No.
of license, not the
Annex 1
consumption.
is by the superintendent.
No, we are concerned about Annexure 1.
Yes.
What is the fact? Just pass an order, huh? Brother, just pass it of my judgment, our judgment. This is our judgment. Not much. Huh?
Great.
Subsection, sub-rule 5. Sub-rule 5, rule 53.
Rule 53. Then 33 sub-rule 2.
33 sub-rule 2. And 41, section 41.
Those are all discussed.
These are all.
Only 53.
Hmm.
Here, no aspect jurisdiction.
Jurisdiction. No, that jurisdiction point is also covered by your Lordship judgment. Para 4.12. Your Lordship has dealt with it. Covered in that judgment also.
Dispose.
Great.
Item number 2.
Same order.
Your Lordship, 97, Your Lordship,
We don't have any brief.
97, the petition has died. What I have verified from the order sheet here.
Substitution was directed.
No substitution.
So
has been
abated.
made. No substitution has been made. Your Lordship, the same order.
Rule 94 of the OST Act, OST rules.
Your Lordship.
Yes.
So after
Let us go. We'll stay.
No, abatement.
Item number
no
3.
steps have been taken.
No steps, sir.
No
That
steps.
is not indicates no steps.
It is brought to the notice of this court that the SSC has already.
Observation, till now, no step.
Item number 3.
Sorry, notes, can it be taken up next week?
These are 2009 matter, old matter. It's still surviving, sir. It's still a lot of lot of water has already been flown in a Mahanadi. What remained?
The issue is still alive, sir.
Still alive.
Still, in the original assessment.
Your Lordship, here is the only interpretation is that EMD, modernization and diversification.
Sir, once you have accepted on the basis of DSC certificate
Your Lordship,
in 12-4 assessment, can you change your opinion?
That
And
is
can you define, can you override that and go in
Your Lordship,
to examine again?
Your Lordship, that is not the question here, Your
That is
Lordship,
the
question of
question.
law. Your question of law is that whether that exemption is allowable or not, exemption is allowable or not. That whether original installed capacity,
He's asking for time. You better explain.
only EMD.
Sir, India Limited,
Your Lordship,
yes.
that over and above only that term.
When you want
That,
next
that
week,
did not,
Next week.
because it
Next-
goes to
next
the
week.
root of the matter.
18th.
That is not the question.
on the prayer,
That is
on the
question
prayer,
number one.
huh?
Check up.
Let this matter be taken up on the next.
Item number 4.
Whether it is change of opinion or not, that you have to
Your
examine.
Lordship,
Now,
only that.
Sir, we have to answer the point of reference. You enlarge the
so there's no difference, but they have raised the questions. So
Yeah,
it is
we have
self-struct revision.
complete-
Item 4, sir.
fresh admission. We wanted to dispose of this matter. We wanted a collective decision to be taken. What is your, what is the stand of the government in this?
180 million, this is 859 million. And
What is your stand? Tell me.
I have received instruction this morning.
Yes.
It is now under the constitution, the government constitution that a decision.
You have to take a decision.
Yes, people.
Why you are restricting it? There must be a rationale behind it. We can't keep it in this way that it is there. We have to then hear out the matter and decide whether this the decision to restrict is reasonable or unreasonable. Purely on the ground of reasonability. You are permitting the other, you are permitting the sale. You are not stop sale. You say that so far as the quantification is concerned, it will be like that. There must be a rationale behind it.
To maintain the uniformity, government is going to take decision.
What going? Since how long you are taking? These matters are pouring in the docket of the court since long. More than 1.5 years has elapsed. Ultimately, it's a sufferance. You are deprived of the excise. Is impacting the government exchequer. Same 180 ml. To be tagged with the item number 48.
Raise the question. Let's discuss about the bill.
Let's call the next.
Item number 5.
180 ml, 6.
In this case, the question number 6 started a foreign liquor shop within 300 meters that clearly violates the terms and conditions of Odisha Excise Act 2008 and Odisha Excise Rule 2007.
Since when they are operating, sir?
September 2000. They are operating it since September 2005.
Recent. So there was a public hearing. So in the public hearing, what has happened? No objection, distance norms, everything has been taken care of while granting the license.
The fact is different, Pillar. Actually, it's shifting from one place to another place. Now the petitioner who has filed the writ petition, on his land, this shop was functioning previously. Pillar. Now it is shifted to another place. So, and other.
So he has a wasted, that why I'm losing,
Now,
My prayer is either to stop it permanent or shift it to any other place. I have made a representation before the authorities.
what was your right? What is your right?
That violates.
He was, that violates the, did you raise an objection when a public hearing was done?
My lord, what happened? One Jagannath Vidyapit primary school is situated within 300 meters. One temple is situated and.
I am asking you that when a particular license is, before the license is granted, the government has to whether there is anything which is within the distance norm. Distance norms is given within this meter, 500 meters or 1000 meters, there should not be all these things. If the government has come up and says that nothing is there, then the rule also provides that the public objection must come. It was duly published. If the public hearing has been done and the public has no objection,
The public has objection because they made.
then how can you show us that the public raised an objection?
My lord.
Show us that the public raised an objection.
Annexed 3, my lord.
Show us.
Annexed 3, that is page 20.
he is the only signatory.
When after the notice was published, within the time the objection was given. So if you do not, then no objection. Give me the rules. Please, rule 33 you read.
Page 20, I made the representation.
Sir, representation must be in accordance with law. Please read rule 31, 32 and then 33. These are the procedures.
Right.
(33)(2).
And lastly, first he must know that how the notices are to be affixed, how the objections are invited, everything he should know. What is the timeline which is given within which the objection has to be filed? And lastly, 33.
My lord, before granting license, they have not taken these measures.
That is not a case. You'll have to then bring all the documents that they have not done it. They must have affixed, they must have invited the objections. There was a public hearing. And once the public hearing is done and the license is granted, then 33(2) creates a renew.
Yes.
So in that event, you can't, unless you show that this is all farcical. I raised an objection within the time when the public notice was published or advertised, and still they are granting a license. If you can show that you have not made out a case.
In fact, there was no notice. They have
We can't. Where is the case? Sir, you don't make out a case at the bar. Where is your pleading? Tell me from your pleading that you have stated this. Do not make an argument without any pleading in the. Where is the pleading? Show us. That no notice as contemplated under Rule 31, 32 was ever published.
32 years before. publication of the notice in local bodies.
That's true. Say that it has not been done. You have not pleaded anywhere, sir.
Public has not got any notice. My
Sir, sir, you can't make out a case. Show me from your pleading where you have stated in your petition. Where is a 4, 5, 6 paragraphs petition? Tell us where you have stated. Tell me, sir.
I have stated page 4, my lord.
Yes,
The
please.
very last
Yes.
the very existence of shop of the opposite number 6 not only violates the terms and conditions of Odisha Excise Act. That means no proper notice has been got to the public.
Sir, I was there for nearly 19 years. Sir. Importance of thing is to me.
Let to be taken any other day. I'll
No,
take-
sir, nothing. You can't improve a case. Your
No, no.
representation is also silent on that.
In my representation and
You have simply said some school is there, temple is here, nothing more than that. You have not made out a case, violation of Rule 31, violation of Rule 32. You have not made out.
specifically I have not stated it, but
So-
in my representation I have explained.
Yes. So let me dictate for the future
No, my-
that whether these kind of are sufficient enough to include and engulf any kind of arguments.
My lord, apart from that, state government passed a resolution not to give any press license. That I have also stated. State government recently passed a resolution stating that no fresh legal license will be granted to anybody else. They have violated it.
What is your stand that previously the shop was operating on his premises. Now, he was a tenant, the licensee was a tenant, so he has vacated and now shifted to some other place. That is the grievance. Is it a true fact?
Right.
Is it a true fact that previously the shop was being operated from your land or on your premises?
That I have explained in my representation.
I am asking you, sir, very simple question. This shop has been shifted to a place. Before shifting, this shop was being operated from which place?
That is in the market,
Which place?
the nearest.
Your property or others' property?
The shop is situated on the main road.
I am asking, sir, it was being operated at your property or some other?
No, not on my property.
Not on your property.
But my property and the property of the school is just adjacent.
I am asking, sir, very simple question. He has taken a stand that this shop was previously being operated from your property.
No, not from my property.
Not from. It's denied. So we'll record that is not, but it's still. Uh, okay.
agreement you are showing.
Anyhow, we do not intend to.
He was operating there.
Yeah. Else.
Please record that.
So now that hearing notice goes.
In the meantime, we should notice for hearing.
In order for shifting based on an objection which was filed much beyond the period which has been prescribed on Road Trading FC. The same order means Ranjit Raut judgment covers Your Lordship. This is the same.
That's it. Don't take it. Stop saying.
And he is conceding to it.
No. I will, Your Lordship, what I'm praying is that Ranjan Raut's judgment covers it in my favor, my lords.
You have raised objection.
No, my lords. I'm a license holder, Your Lordship.
Yes.
I'm a license holder.
The shifting has been.
Yes, my lords. So shifting has been ordered on an objection which is beyond this period of Your Lordship, 15 days. my lords.
What more?
I would take short instruction whether it is within that time or not. Okay.
Let's keep it in the next week. You
Yes.
take an instruction.
So Lordship may protect me till then because they have given me only 15 days time to shift my ship. Lordship may have a look at
It is
it.
going to expire.
Well, it's already expired. So I have given them a letter that my case is pending. Lordship, my interim application is also on the board. Lordship.
That's fine. Interim order has to. And it is a covered case. If he has been taken in the instant writ petition. No. What he's doing?
Lordship, an urgent supplementary.
You think no?
He'll be downloading. Just pass through this.
This was the next question.
Grateful, Your Lordship.
Item number 7.
The issue is covered in the same file. Hope we need that. So, this was in a.
Item number 8.
The petition to pay lordship is a cooperative society rules. And as per 80P of the Income Tax Act, its profits are to be exempted. But
Profits are exempted.
But subject to the rider that there is an audit conducted of the audit under 4480. So far as this particular cooperative society is concerned, it's registered under the Odisha Cooperative Societies Act 1962. As per
There are certain categories of cooperatives. So that's why it's a housing cooperative or
it's a thrift society of the Reserve Bank employees. So, Lord, as per the Societies Act, Lord, Odisha's Cooperative Societies Act.
So it's really a housing society.
It isn't, Lord. They invest money, and if they need some money, they borrow money from the society, and that's how it runs.
That's it.
Pardon?
That's it.
Like, so, Lord, the accounts have to be audited by the state authorities. Now, for the account of the cooperative society under the Cooperative Societies Act, the state authority
It's a credit cooperative society.
it's a credit cooperative society. So, what has happened, Lord, is the AG of cooperative societies, it says that we are running short of staff, So you do select the other private auditors from our list, take that consent, give it to us, and after we approve it, get the audit. In the meantime, what
What
happens?
does it mean? From your list of auditors,
Auditors.
what are you talking? You engage them or whatever?
They say, Lord, if your Lordship would read the letter. So what has happened?
How can you? They can engage an independent auditor.
They cannot do it because they say that we are running short of our statutory auditors. So we are maintaining a list of private auditors. You select.
You say, I just thought that you have imposed that.
No.
That
So-
these are my list of auditors. You choose
no.
one.
So amongst the list maintained by the AG of audit, you select a name, get his consent, give it to us. After we approve, then the auditors carry it out.
Correct.
In the interim, what happens, Lord? My return enrolled filed for the period 1819 to 22-23 because of lack of audit. But this has become a pan-India scenario, for which the CBDT, it came up with a notification. As per the CBDT's notification, the principal commissioner has to give a report relating to the reasonable cause, whether there's a reasonable cause for not getting the accounts audited. In this particular case, the principal commissioner, he gives a report in my favor. Still, the principal commissioner Odisha region rejects it because he says that you should have not taken appropriate steps for getting your accounts audited. That's why I reject your application for condonation delay under 119 of the Income Tax Act. My humble contention, my lord, is he has completely, my lord, ignored, my lord, the CBDT circular, basing on which the report of the principal commissioner was given, my lords. The cooperative department of Ministry of Cooperative Department, they have also said, my lord, that this is the pan-India problem. Please approach the authorities of the Income Tax Department, ventilating your grievances. That was also ignored, my lord. And my humble contention, my lord, is there's no plausible reason, my lord, assigned by the principal commissioner for rejecting my delay condonation application, especially when, my lords, there was a reasonable cause for me for not getting my matter accounted. And now, my lords, ATP has been rejected. My lords, investments have been treated as unexplained investment under 69. Demands have been raised for the entire period. Appeals are pending. But that becomes superfluous because unless I give the audit report, the appeals will also be confirmed. But for a moment, my lord, your lordship, kindly, my lord,
Now the audit has come.
audit has been completed in 2024. But before that, my lord, my assessments were completed under 140.
So when you go to publish this audit report, they're rejected for.
On the ground, delay, no, that's it.
119 to be
Month.
empowers the authority to condone the
Condone
delay and accept the audit report.
Month.
There is no outer cap given for condonation.
Well, that is the CBDT circular. If you're-
I'm asking you, sir, is there any outer cap which is fixed?
There's no, Milord.
There's no order.
No, but the CBDT circular says that for the period 1819 to 22-23, the principal commissioner should inquire into the matter, give a report, whether there was a reasonable cause or not, and thereafter you can do it. No,
That is what is there. That means the discussion has been explained.
Man,
And if there is a reasonable
Cause,
which is short, then there is no difficulty.
and what is reasonable cause in the 10B application?
It has been given a favorable one.
Malum,
The authority rejects it.
rejects it because they say that you have not taken appropriate steps to get your account on it. If your lordship may take up my additional affidavit at flag evening, where I've annexed the CBDT circular and the report, my lord, of the principal commissioner. Issue while dealing with the matter of 10B, that what is reasonable.
And 2B also, we have passed the judgment. I think Mr. Garai is raised.
That was related to 10B.
Yes.
But is pending.
No, 1192B, relay condonation.
Relating
Perhaps
to
exemption.
exemption or 10B.
10.
That your lordship has held, what is reasonable cause? The lordship has additional affidavit and
That is also a delay furnishing.
What do you
Yes,
say?
auditor.
These are the factual aspects.
Submission before the
Beyond the CBDT circular, and when the actual authority has also signed the reasons that what was the stumble block, and what was the obstacle which was there, we were not consider in a pragmatic manner.
That is what the Bombay High Court has also said below that a pedantic approach should not be taken.
That is what I am asking.
Lalit, the fact is that the order has been passed by considering the report furnished by the principal commissioner. The order has been passed by the principal chief commissioner, and the order has been passed considering the reports of the principal commissioner as well as the jurisdictional assessing official.
True.
And the two things there, the account, the assessee has not yet able to audited the accounts within that
But they
period.
say that they have to engage their auditor.
Right.
Who will engage the auditor?
The petition.
That is what is his case. Who will engage the auditor?
No, the independent
Sir, are you
auditor.
disputing
Sir,
that?
it's the individual, I know, in the individual and the companies, but this is a special cooperative society.
Right.
If there is a provision that it's only the authority who have to,
Under 62 of the Cooperative Societies Act.
they have to nominate the auditor, and the auditor have to do it. How can they defy? You are not nominating the auditor. You say there is a dearth of auditors in our pool. We can't. There are the list. You can choose one, ask his or seek his consent. If he is agreeable, we will ratify it, which he did. And ultimately, the audit is complete. How can you put your ball into his court?
The statement of Mr. Garai,
Right.
that the authority has given sufficient cause or reasonable cause, why that should not be completed during that period? Are you disputing that?
That is what I say. One of the authority who is there at the very primary level, if he has indicated the factual, the difficulties hovering around pan India, that this is what, because you are supposed to nominate the auditor. You were not there. So why he should be penalized?
An appeal will be notified.
The delay condemnation filed after initiation of the reassessment proceeding under section one.
Whatever be the reasons.
What will you gain by not accepting this audit report now? Are you going to gain anything?
No.
Then
This is how it happens, and why he should be. And absolutely a pedantic approach has been shown. You have to discard that this reason is not acceptable with plausible reasons, that this is what the reality is. This reason which is assigned by the commissioner, not accepted. You have not. It's a change of opinion. That's not.
Section 62.
That's
62
your
of the
cooperative society.
Odisha Cooperative Society.
Exactly that. Or then 64, I believe.
Subject to correction, 62.
I know it's the same law. They're the
The letter-
sections are different.
In the letter, your lordship could see that page
You
43.
see, the auditor general shall so arrange the audit that the same auditor shall have audit the report. So it is the auditor general who is to take.
And your lordship sees the auditor's general letter at page 43 of the brief. He says we are in the 43, your lordship, can you see?
What, sir? It's really a stalemate situation. What do you do?
Allow one shot at the take is okay.
The CBDT circular note covers this.
That's true. Asking for the time. That's nice.
You are not brought up the appeal, pendency of appeal.
Appeal is pending. But my
Have you sought for?
stay. No, I have not, because
No, you are not filed in IE.
no, I have not filed any. Not.
No. Appeal is pending, no, that's still.
Because unless
In the middle, he is seeking for time. And
I'm not, I'm sorry. Can it be for 18th, not subject to law?
Why?
Next week, sir.
Next week, that is what they are fixing. Next week. On his prayer.
Item number 9.
Intentions government failed for you.
Item number 10.
It is a seek to challenge under the two by passed by the blue in not adopting the section 3 of the Excise Act and pass the order in a very whimsical and arbitrary manner. The fact of the case
Pass an order in a whimsical and
in the arbitrary manner, my lord, this is the case at hand.
admitted manner.
Yes, my lord. Sir, this is the case at hand, my lord.
Arbitrary.
This is the case at hand, my lord.
So which,
The-
where is annexure 2?
Annexed to the impugned order, my lord.
Where is that page?
Page 22, my lord, wrong page
22.
23, my lord, the order passed. May I read, sir?
you have,
Which is this
matter
related to 73(4)(b).
yeah,
73.
4B,
let it
it
be
served to us. It is matter related to 73(4)(b) and a copy of
What is pending before the Supreme Court?
a copy is served. So just now I will sort the copy, my lord. I have the extra copy.
Copy.
limitation is
Limited.
very good.
Yes, same order. 73(4)(b) adjourns another into production cost.
My lord.
Item 11. Item 12.
Well, picture. In this presentation also, petitioner will also search for direction for the first operate of the expeditious disposal of housing. Let's see how in disposal.
Yes, it has already been disposed of.
Yes, sir. Independence of this present.
So it has become instructions. So the instant expedition was filed by the minister. Yes, subsequent order and not. We have disposed of.
Item 14.
This is not order under the service tax, which has been passed against a dead person. And in spite of the fact that this particular cause that may not have intimated to the authority. The Lordship of kindly see, a show cause notice was given on 30th of December 2020, with Annexure 2 at page 35.
What do you say? They can proceed against the dead person.
Similar matters have been pending and I filed a counter.
Which, where is it?
Dead person.
How?
Just a dead person is.
Similar matter, yes.
Oh,
I
keeping the numbers.
Yes.
Tag those matters.
In course of the game.
How?
You are proceeding with this, heirs or no,
Against the dead person.
It's against the dead person. The recovery is also against the dead person.
dead person or heir?
Unfortunately, against the dead person.
So,
Dead person.
so
Similar matters have been pending.
give me the number.
In course of the day, my lord,
Again, we are fixing all those matters in the next
There's an interim application for stay of recovery.
one week. What is going to happen?
18th.
The returns were scrutinized, and on the basis of the scrutiny, an explanation was sought for from me regarding certain discrepancy. Section 61 says, if the explanation furnished by me is satisfactory, the matter comes to an end. They do not proceed beyond that. If the explanation is not satisfactory, then they'll proceed under Section 73. I have filed a detailed explanation. My case is that I have paid tax to the supplier didn't deposit. My summation, my lordship, that in order to come to a conclusion that there is no satisfactory explanation, my explanation is required to be considered, my lord. They have to apply their mind to the issues that I have raised or the points which I have pointed out. Then thereafter they may come to a conclusion that yes, your explanation is not satisfactory. Therefore, we are proceeding against you under Section 73. So a finding has to be recorded that explanation is unsatisfactory. My only limited grievance is that, my lord, my explanation has not been considered in the correct perspective, and there is no finding that my explanation is unsatisfactory before reading it.
Where is that finding?
My lord, there is no finding, in fact, my lord. Only the explanation which furnished, and moreover, my lord,
Where is?
I'll come to that, my lord. One more submission is that, my lord, much prior to the issuance of notice under 61, I had indicated that my supplier is not depositing the tax. So please, you ensure that tax is paid to the government, because I have already paid the tax to the supplier. So this is the year 2024, much prior to the issuance of notice under 61, my lord. You also may see my explanation.
This intimation must have triggered this notice.
Maybe, my lord. Because I said he has collected the tax, but he is not depositing. And there is a provision against non-deposit, they can put against that same, my lord. Sir?
Yes,
Notwithstanding your intimation that the supplier has not deposited, you are aware.
Sir.
So.
You have that credit.
So that's why I'm saying, my lord, if the explanation,
So the law says that unless he deposits, you cannot.
I cannot claim the ITC, my lord. That's
You could have deposited that amount at the protest,
protest.
and then
I've given the details of the invoices in which I have paid details, everything, my lord.
no doubt.
Yes.
We will proceed on that basis.
Yes.
Now, what is the law?
I have deposited saying that it's under protest and I have to claim
You have not
refunds.
deposited, you intimated to the department, yet you availed the benefit. Then
But 61 says, my lord, if the explanation is not satisfactory, then
where is the finding you just said?
Yes.
That in one line says not satisfactory.
no, even they have written that, my lord.
Where?
Yes, I'll come to that, my lord. Your Lordship may see page 49 and extra 5 is the notice which is given under section 73. This is subsequent to 61, my lord.
Where is an independent finding which you
No, my lord.
61?
Yes, my lord.
There is one now 2.3 here, page 52. Point number 2.3. Page 52. 52 matters.
Yes, but that's the ground that you have availed.
No, no.
The input tax credit.
They only
you availed, and therefore this explanation is not satisfactory.
they only recorded my contention.
No,
They
sir,
should have
the
said
last paragraph.
this is not acceptable. They
Sir,
should have said this is not
last
acceptable.
paragraph, the
Yes,
notice, the notice has acknowledged
Yes.
that the core issue in the present case pertains to the interpretation of section 16(2)(c) of the CGST, which mandates that the tax charge in respect of a supply must have actually been paid to the government by the supplier as a condition for availing ITC. That's the law.
This is my contention. I am
This is
advancing.
the law.
Yes, madam. Yes.
Then he says, in the light of this provision, it appears the noticee by availing ITC
Yes.
under such circumstances contravened the provisions and therefore not satisfied. Had it been the case that you did not avail ITC, I can appreciate that your genuine
No.
nuances.
There is no dispute on that. I am availed, madam.
So what can be done, sir?
So what I am saying, madam, let them consider it in proper perspective.
Not the proper perspective, what they will consider. The
Madam,
facts are undisputed, sir. The facts are undisputed.
the supplier deliberately is not depositing the money with the government.
They will go and collect it. But you should not have availed the ITC.
Yes, weird, madam.
You have done
From
it.
that I cannot escape, madam.
Well, it's Shoka's notice.
That is at the stage of show cause. So you give a reply, let them consider. In the meantime, if we deposit the money with some kind of a condonation or something or a proceeding, take advantage of that subsequently. What else?
You know, observe that I filed a reply. I mean, even if that deposit, madam.
No, that is what is the presupposition.
Your boss is saying you deposit, madam.
No.
It's a fail from your hardship only, my lord, that you deposit. You should have deposited, you should not have availed that.
You have the remedy there, KV Muhammad.
Yes.
Item 17.
7349.
Item number 18.
In absence of the GST right.
Item 19.
And he actually took a cancel man. I see cancellation. This is important.
Item 20.
In this case, there is a delay of 80 days in filing form 20. And similar document are already developed this meeting.
I will seek your order. I will seek this order.
Thanks. Yes, ma'am.
I could have gone taken a view. I think based upon this. My view is also there in Calcutta. So,
21.
My lords, I appear for the petitioner. My lords, in this case, there was an inordinate delay of 18 years in granting the refund of customs duty by the customs department. Lords, in the year 2007, I had filed shipping bills. The customs department had provisionally assessed those shipping bills and collected excess duty. Mandatorily, they were required to finalize the shipping bills within a period of 6 months. My lords, it took them 18 years to do so. Subsequently, my lords, since there was such a huge delay, I filed a claim for interest on the delayed refund. My lords, in this regard, I relied upon my lord's own decision in the case of Vedanta, wherein it was on identical facts. It was held that the finalization of assessments has completed within a period of 6 months, and in case there is any inordinate delay, in that case, the assessee is entitled to claim the compensatory interest. My lords, may refer to the impugned order. My lord, they refused to follow the decision of the jurisdictional High Court on the ground that the same is not accepted by the reviewing authority, and they may be filing a SLP before the Supreme Court. So far, my lords, they have not filed any SLP.
They could have kept the matter pending.
My lord, but so far the order was passed in May 20.
They have disposed of.
They have disposed.
Suppose the SLP is dismissed. What happens?
SLP is not filed yet.
Let us take the extreme case that you find as dismissed. Then can you reopen? You have to keep the matter pending if you really intended to go and challenge that order before the Supreme Court.
My lord's
dispose of the matter.
My lord's order was passed in May 2025.
If they took up, if I accept what you say, then in that event, how can you dispose of it?
1 week will be done. So I will take discussion on that aspect.
Then it has to go and it should be kept pending. If you go for SLP, fair enough. If you don't go, then decide the matter on merit.
Next week.
Where is the finding that it says that
Lords,
is not acceptable?
page
and,
number 46, my lords, para 5.7. 5.7, page number 46.
Okay, the operative portion of the order cannot be. This cannot. This paragraph in this one. Only two paragraphs.
You have call book facility,
Yes.
so you should have sent it to call book till finalization as you offer to Supreme Court.
1 week maybe after take instruction or not?
Yes, it should remain alive.
Yes.
The proceeding should remain alive till that judgment is tested.
My lord, within a reasonable time, it's already been more than 6 months. They have
Second
not filed
file
this.
is there for even Article 136. What is the difficulty? It all depends on condition of the bill.
But it's a reasonable time. So
Therefore,
3
you can't
months.
say what is reasonable and what is not reasonable. Just tell me. 5 days may not be reasonable. 500 days may be reasonable. Supreme Court has said
My
the
lord,
length of delay is immaterial. It's the sufficiency of the cause which is material.
my lord, I'll continue to suffer. There will be no interest on interest. I waited for 18 years. My lord,
I
they
think
can
under
grant
the
me the
Interest
refund.
Interest Act, that concept has gone.
My lord, they can grant me the refund and then they can file an appeal and keep it in abeyance. And if it is set aside, then I'll return it
Give a
back.
bank guarantee of the entire amount.
Bank guarantee I cannot give. I can give an undertaking. I can give a bond.
Suppose if they succeed and the order goes, then what will happen?
My lord, I'll have to refund along with interest then.
Then what is the guarantee for the?
I can give an undertaking because this order is binding, my lord.
Then you'll have to secure that amount. Give a bank guarantee to them.
I can give a bond, my lord, so I can give an undertaking. Bank guarantee, then it's as good as not
Give a
getting.
bank guarantee so that they will in cash. Security, it is not a one-way traffic. There should be an equilibrium which should be brought to the court by the court. How to ensure the equilibrium?
But in that case,
Putting over
they can,
terms.
my lord, in that case, they can keep it in abeyance for a reasonable period of time.
Yes, I have one concession by the
I have gone.
standing senior standing contract, saying that you reduce the rate of interest.
Yes, so that has been accepted.
Okay, it has to
Yes,
go.
yes, yes,
It has
1
to
week.
go.
Yes.
Why 1 week time?
I will take some study. The first time this
We will
case.
simply record that this cannot be a ground. If the conscious decision is taken to challenge that order, then you should have kept this proceeding pending. You should not have disposed of because it all depends upon the ultimate the fate of the SLP if at all filed. And there should be a reasonable time of keeping the matter pending.
Unless that very judgment is,
Yes.
operation of that very judgment is paid, then we can understand.
You cannot file. Possibly in this one.
different parties, same group, and exactly same issue. Same order will pass. Yes.
Different scenarios.
Yes, different shipping points. Yes.
Item 22. Stand by law.
Number 22 relates to 74.
Item number 23.
May it please your lordships.
Yes,
May it please your lordships.
yes.
Lordship, this petition challenges the notice issued for a consolidated period for 2021, 21, 22, 22, 23, and 23, 24, my lords. Identical matters, your lordships have passed orders.
Is a composition, is a
Composition
of
noted.
the several
Yes, my
periods.
lords. Yes, your lordships.
Relates to, they have already appeared and they have challenged the so-called notice. Let them file the reply to the so-called notice.
You file a reply, but the composition that can you club together all the periods in one notice?
That has already been decided by the Honorable
What?
Delhi High Court, which was confirmed by the Supreme Court in the case of Mathur Polymers. Tax period may be considered accordingly. When a tax period will be taken
Under GST. Under GST.
clearly define the tax period means it will be.
Each tax period is separate component for assessment.
Lordships.
Tax period for which returns are due or returns are filed, which is considered to be separate component for assessment. That is the position.
They can issue the notice for multiple tax period within the one single notice.
In our case, our court also one order is there. In our case, these are the VAT division order. You don't. License.
Lordships.
Tax period.
It was a case for ITC.
No, my lords, no. In fact, this decision has been considered. My lords, this decision has been considered by division.
Reverse charge mechanism.
My lords, one.
Tax will be paid on reverse charge mechanism, and they have already paid some amount out of 500.
But when you were citing a judgment, this was a case of ITC, and where the Delhi High Court has given a reason for that the court is has fully considered a statutory scheme as also the legislative history of the GST, held that in cases relating to availment of an input tax credit, considering the maze of transaction, and due to the fact that the transactions may spread over several years, issuance of a consolidated notice for multiple financial years would be permissible. So that was in relation to ITC.
Yes.
What about this?
No, my lords. This is a tax demand, my lords. And my lords, may I just point out,
This is what is the.
what fell from my lords is precisely
We are taking into consideration.
Sure.
We are in a, I think we are still considering that point.
Lordship, may I just point out the division bench of the Bombay High Court precisely pointed out this, that was a case of ITC and distinguished it. There's a division bench of Bombay High Court. The Nagpur bench in Bombay also followed the same. There's a division bench of the Andhra Pradesh High Court considering this judgment again. There's a division bench of Kerala High Court again considering this judgment, my lords. What fell from my lords, my lord. And your lordships are considering
Why
this.
not the reference is also given to this High Court?
Lordships.
We are referring to Karnataka High Court and what about Karnataka High Court? Whereabouts? What about that?
Yes.
Any further progress? They are not verified.
Sir, mere dismissal of a special petition does not mean a affirmation of the merger of the order.
But in this case, this is also a supposed notice.
Maybe if the
They have agreed-
very foundation, can you visualize? Adjudication would be done on the basis of the show cause notice, which is a foundation of the any proceeding. If the foundation is found to be defective,
Your lordship,
can a castle be built on that? I am asking you.
they have agreed and paid tax on all these multiple periods.
That will take away the challenges. A legality of your
So
We will consider the concept of waiver and the acquisitions. We will consider it at that time. Not at this stage, yes. Let's call the next.
Lordships are passing these identical order, my lords, because they should
Yes.
not adjudicate the notice.
Yes.
Item
Lordship.
24.
Grateful. I'm obliged, my lords. I'm obliged.
24.
Yes.
Similar.
What similar?
1 and 2.
Multiple.
Absence of history pattern.
Oh, I say that. Oof. Yes.
Item number 25.
Give. Yes, both. Oh, sorry, all. 3. Okay.
25.
Individually you do it. Huh? Why with every time? $26.
Item number 26.
26 regarding 73
$27.
Item 27.
Challenge the so-called notice which is given us through 750. There is the second and third so-called notice. Original so-called notice of final after adjudication, appeal has been filed by the department and then appeal has been dismissed. And again now they have issued the so-called notice. Kindly have a glance to annexure 1.
No, under different context.
No, same. Here, fact is that I have applied.
Same transaction. Same transaction.
Same transaction. Applied for a refund.
Same transaction.
Oh,
But different context.
definitely on a different context.
Kindly have a
The
glance to
incident may be different. Incident may be different.
page 22 of the so-called notice.
Isn't the fact?
I take instruction on that.
No, your appeal
Yes,
has been disposed of.
Yes, sir.
Against 73,
Yes, fine.
which was dropped or allowed
Yes.
in his favor.
Yes.
Again, you have claimed 73
It should super.
on the same transactions.
For the same incident
Yes, that I have.
or the event.
What
Yes.
did so you could have? Has he not enclosed the
To have received the funds.
Kindly have glance to just page 22, single line. That so-called notice. Page 22 of the so-called notice. Second para. Last line, the refund application is processed and transferred to the taxpayer and details thereof are furnished therein. I have applied for the refund and after issuing so-called notice, they grant the refund. And that is the refund amount they have mentioned in the table. On further verification, the above referred 3 RMT 01, it is sanction order. It is noticed that taxpayer is not entitled for refund as discussed therein.
So
But
it's
that
a
is the
change
final
of
date
opinion. It's a change. Then why don't you challenge this order?
Yes.
Whether this so-called notice has been dropped or they have said it to
No, no.
appeal before the tribunal.
Recently, they have given personal hearing is on first note. They have issued the notice. And against the so I have given us a reply. That reply is that. After that, again, kindly have a glance. They issue those notice in page 31, annexure 1A. Against this notice, I have already filed the reply, stating that all the fact. That reply is also there.
Erroneous refund sanction.
Yes, this is annexure 1A 31.
Anyhow,
Erroneous
you have to
refund.
challenge the order. If the order has been passed, then how can you defy and then initiate a fresh proceeding? That means you are trying to overreach that particular order which has been passed earlier. Can you sit over an appeal as an appellate authority over the order of your coordinator or your own order? Let us go.
Subordination.
Absolutely.
You are discipline proceeding also.
In similar issue, recently Jharkhand High Court given the same.
No, understood. We understood.
For finality. Yes,
Understood.
for
1 week. Next week I will.
Next week.
But there is
Then don't
personal hearing.
Personal hearing when?
I was no, because there are as per the adjournment.
Correct. Now adjournment, please see that adjournment is there. When
Right.
tomorrow, next week you come on that.
at the request of Raj Subri. Sujan,
Yes.
next week for instruction.
Item note 28.
Again, the GST Act, Trade GST Act. Here I am not a registered dealer. CP. They have generated a temporary ID and without serving any notice and giving
They
any
have only
opportunity.
uploaded. They have only uploaded in the portal.
SMD 14 is uploaded, but they intimate me on that is annexure 5 that
Page.
page 34. November 25. Sorry,
To mail.
22. 7 September 22.
What?
Page 34.
Where do I get it? That is the 8th November
No,
2025.
that's
7 September 2024.
forwarded message there.
Yes, sir.
Against this, I filed the appeal.
Okay, I got it. No, I got it.
But here is the case, they have relied on the WAMIS data. But during this period, I am not doing any work. I am also not a registered dealer also. And
No, you may not be registered dealer. Your data, your works contractor.
I was
Earlier, yes.
I was a master. Since
You must
2016, I
have-
am not.
You must have received some amount in respect of your work executed earlier. That is uploaded in WAMIS, that is government management system. Right. So that payment being made to you, they must have got that information that
That is the point.
you have not discharged the
That is the point,
liability, even though you remained unregistered during the post GST.
GST. But kindly have glanced to annexure 8 by 26 AS. That is the income tax. So there is 0. What happened? Whatever there is a debit and credit entry.
Where, which page?
Page 41. There is a 26 AS. That is the income tax data.
Well, I understand.
In executive engineer, Ganjam, R&D, the amount is 00. But what happened? There are certain transactions against my PAN number. In response to that, I have applied for RTI.
Yes,
For
period
1920.
is 1920.
Deposit of the tax.
So in response, after looking to this, I asked for RTI to the R&D division. So kindly have a glance to page 46. That is the reply by the R&D under the RTI Act.
inviting the kind reference on the above cited, it is stated that there is also two number of contractor in the name of Sikandas having PAN number and another Sikandas having PAN number so and so. In Wami's data. While preparing the bill dues, clerical error in the first PAN number has been used. Hence, the accounts of the Wamis shown in the favor of the Sikandas and PAN, this is my PAN number. But soon after detection of the error and claim of the actual Sikandas, necessary correction filed in the Impeta Seaton and rectified, which also reflecting the 26S submitted. Hence, this may be treated as collision mistake. So there is
The income tax department has also accepted that.
and what is the
Because it
observation
was
of-
wrongly, there are two contractors, wrongly PAN number of the petitioner is used. Actually, this must be of another person.
In fact.
So that is what,
Should be, but 2022, 2020. I'm not on the way, only I'm.
For the sake of an objection, you are raising an objection.
No, not objection, Your Lordship. Not objection, Your Lordship. So far as the delay and lapses on the part of the people.
No, sure.
Forget about it. It is genuine
Sir.
claim, should not be defeated on that.
Sir, Article 65.
A genuine claim.
Assessment order has been passed in 2021-22. In some cases, 21-20. He is well within the knowledge. The demand has been delayed. He has filed appeal. Appeal has been disposed of in 2025. Then it has been confirmed. In 2025, he has gone to the supplier that this is not my demand. So let me verify.
What verify?
Let me verify.
Then verify. A genuine claim should not be defeated on a technicality.
Your Lordship, whether it is that aspect, let me take.
They have come that it is wrongly done.
RTI information he received in 2025.
Why?
He has applied in 2020.
Whatever, that he found that why these transactions are so 26 years when I have not done. Then naturally he approached them and the authority has said, yes, it is a mistake which is committed by us.
He has taken 3 years, 4 years. Let me take 1 week. Let me
Whatever.
take 1 week, Your Lordship, to
For that, for no fault, can you penalize him?
No.
No, he is asking for time for that.
Let me take 1 week time. He has taken 3 to 4 years. Your Lordship, let me take 1 week time to take
appeal has been
Then
passed by the-
don't plead.
What is the observation of
Let
the
us
officer?
on
Obviously,
Yes,
that's
it is.
Your Lordship. is
These
very-
these were not brought to the notice. What have we done? You are reading it for the first time before this.
26 has not been.
No,
That is,
this RTI information.
first updated order has been mentioned about 26 years. There till it is irrelevant. 26 says irrelevant.
Sir, whether this reply under the RTI was filed before the appellate authority.
That was not.
That is what I'm saying.
26
So
years.
if 26 years reflects your PAN number, what more? They may have taken a decision, it has no relevance, we will not go into it. But this is a very alarming one when you say this 26 years contains the wrong name. It is not my transaction, it is a transaction of another, not my name. That's a very vital, that it does not pertain to you.
And it has been reflected in the WAMIS data. So I have to verify.
What verify? The authorities have said that I have rectified it. Now download it, the correct one.
Your Lordship. And also, I don't want to be so technical. Also, both previous other periods are the ground of delay. So
Harichandran, for 161, time has gone.
everything time has been done. Your Lordship, these are the matters of 2021-22.
In this
And he has applied under RTI in 2025.
In this
After
case-
disposal.
Appeal, that is what it says, that appeal,
Now 161 appellate authority can do.
what's the appropriate time? 3 months is there.
161.
outer limit.
Like outer limit is
There is
no, outer limit is 6 months.
Is there.
6 months. Order to be passed within 6 months.
No, not condonation.
No, not that.
Sorry.
Not beyond 3 months, the condonation power. I'm just
Not
asking.
9 months and like that.
There is nothing. So there is no outer cap. It has a power to condone, it can condone any period.
Only mentioned within 6 months they have to pass.
That you'll have to. That is a different.
Language is very clear. No such rectification.
What?
shall be done.
For the next 1 week, next week.
So let's see, can it be taken last week? In this way, it has already.
8 January. Item number 29.
RC, both.
Item 30.
Second one I'm appearing. What? Second is.
First one I am appearing, second one is.
Item 30.
Notice on the 148, contrary problem.
Baseless.
Baseless. Pending.
151.
No, he has given a correction. Correct. Yes,
Item number 31.
not to me. My God, some reasons.
Item 32.
One minute, they have not got the copy on me.
Which one? 32?
32.
31 when I will not pass any order.
Item 32.
Is a case about where contrary to section 27, the officer says that they are trying to open the law in spite of objection of the Gram Sabha.
On the grounds of?
They are under objections of the Gram Sabha. They are trying to open a outskirt liquor shop in a scheduled area. So far, scheduled areas are concerned, section 27 of the Orissa Excise Act about stipulates the Lordship would
Now we have already decided something, this objection when within the time, out of time.
Because section 27 gives me 30 days to file an objection.
For granting or
For objection, the Lordship will kindly take up section 27.
But what about the rules?
No, section 27.
What about the rules?
Rules, my lord, it says for scheduled areas, it's also 30 days now. 31.
Yes, that is what I'm saying. Rule 31 also talks about the schedule area.
Proviso, it talks about 30 days now.
Correct.
So it's in consonance with section 27.
Yes, so within the time you have raised objection, then hearing has to be done.
No, the hearing, my lord, they do not give me a hearing. They extend, my lord, the license, my lord, till the new excise policy comes. And your lordship would appreciate.
What the extent? The license was already granted.
The license was granted, the shop was not opened.
Okay.
Thereafter, my lord, for the assessment, for the financial year 24-25, I challenged it. That became, my lord, time barred because of the lapse of time. In 25-26, my lord, if the lordship would kindly take up the license, that's at page 30. And actually 3, my lord, page 30. The license, lordship got it. After that, the license shall remain valid from 1/4/25 to so and so, but they have extended it until superseded by the new excise policy. So since the new excise policy has not come, the license has been extended. And the lordship would appreciate, my lord, this is, my lord, contrary to their own commissioner's letter, my lord. The lordship would kindly take up the commissioner's letter at Annex 6, page 40.
No, the meeting was held on 21st of February 2025.
So that is about the Gram Sabha meeting.
Okay.
So that is pursuant to the objection sought for by the collector under section 27.
Yes.
I've given the translated copy if your lordship. That's immediately after page 23. If your lordship can kindly see the translated copy of Annex 1. It's Basantpur Gram Panchayat, under notice item 27 of the Orissa Excise Act. This is to inform you that the government has purported to grant renew the excise shop license of Keonjhar district in the financial year 25-26.
Where you are reading? I'm unable to.
After page 23, my lord, the lordship would see the translations, my lord.
I know, I was just.
After page 20.
No. Yes.
Page 20 is a translation of page 19, my lord.
It should be paginated in a fashion of 22A, 22B, or 23A, 23B, 23, because it pertains to a.
Manoj,
Yes.
I'm sorry, Manoj. So this is, Manoj, the notice which was in vernacular at page 19.
Yes.
That this is to inform you, that the government has proposed to renew the excise shop license shop in Keonjhar district for the financial year 25-26. The details of the specified area are given below. As per section 27 of the Odisha Excise Act 2008, the approval of the Gram Panchayat with the concerned village administration is required for the grant or renewal of excise shop license for this shop. Therefore, the decision of the village administration and the Gram Panchayat regarding the proposal should be communicated within 30 days. If the decision of the Gram Panchayat is not taken within the said time limits, then the Panchayat shall be deemed to have approved the proposal as per law. If the Lordship would kindly come below to one page thereafter, below. The area, Milord, is Basantapur. The second table.
Serial number. The column is a serial number. Just give me.
Serial number 2, Milord. After one page, Milord.
First page. That is a Naranpur.
That is
no. That is a you are referring a column.
No, the column, Milord, is after the immediately after that page, Milord. The page which I read, Milord.
Yes. So next page is a column.
Column, Milord.
So second. Thereafter.
Thereafter, Milord. The second column, Milord.
I am talking about second column is a serial number. That's why I'm saying it will be very easy to come in.
I'm sorry. That's after serial number 35.
35. Yes. Yes.
Your Lordship may come to the second serial number.
Second. That is a Pandapada.
Pandapada.
Yes.
And I am concerned with Basantapur, Milord.
You are, yes, it contains two, Binida and Basantapur.
So I am concerned with Basantapur.
Correct.
And if your Lordship would see, Milord, after the PESA Act has come in, their own letter of the Commissioner, if your Lordship would kindly turn to Annexure 6 at page, Milord, 40. Because they have made, after the PESA Act, they have made a lot of harmony between section 27, 44 of the Gram Panchayat Act and the PESA Act. Your Lordship would see, to all collectors, Korapur, Ganjam, these are all the scheduled areas. Then they say implementation of the provision of the Panchayat extension of scheduled areas.
Understood. Then
the Lord, your Lordship would see, turn over the page at page 42. The last line in bold letters. No excise license shall be renewed or granted in the scheduled area if the Gram Panchayat has not.
What is the authenticity of this?
No, it's signed by the Commissioner. It's signed by the letter, my Lord, is number is this, and in that own excise policy at page 38. Your Lordship would kindly turn to page 38 is the excise policy for 25-26.
So says that unless the Gram Panchayat and the Gram Sabha both have given their consent, it will not be approved, either grant or renew.
They have incorporated this in the excise policy itself at page 30.
That was 2017 policy. Then what is the current?
Your Lordship may see 25-26 the excise policy at page 38. No? The relevant page. No? Roman 14E. Page 38. No? Roman 14 small English E. No? Collectors shall strictly adhere to the provisions of the PESA Act 1996 and the detailed guidelines issued by the
That is that guidelines.
That is the issue letter which I just read before your Lordship, dated 17/12/2017 and serial.
Again says no shop in the such and renewed if the Gram Sabha has
incorporated this letter, the spirit of the letter in the excise policy itself.
Yes, sir. How can you?
Lordship, you kindly see page. The notice that is at page 24, which my Lord Senior referred to.
Yes.
The District Excise Office, Keonjhar, 13/1/2025.
Yes.
So Lordship will find this was issued on 13/1/2025. And any objection by the Gram
Just
Panchayat.
1 minute. Page,
my Lord.
24.
24, my Lord. Notice. This is to inform that the government has proposed to grant renew.
Oh, this is what he referred.
Yes.
Yes.
Your Lordship may kindly mark the date 13/1/2025.
The date of the notice is 13/1/2025.
Date, but when is
The Lordship may kindly come to page
And-
23, my lord.
And,
Just one minute.
and
Page
objections.
service?
It is served on 31st January 2025 at page 23. The executive officer, Basantpur Gram Panchayat, he receives it at page 23, left-hand column at the last, my lord. Executive officer, Basantpur Gram Panchayat, 31/1/2025. That is the date of receipt, my lord, sir, by the executive officer, and he communicates this to us. And thereafter, my lord, we file an objection, my lord, immediately on the 22nd of February 2025, within 30 days. And I've taken a specific amendment to that effect, my lord. If your lordship would kindly, my lord, come.
So definitely from the date of the communication, how they will know what you have taken a decision
And your lordship,
and keeping the file with you. The moment you communicate, the 30 days period must reckon from there.
and paragraph 3 and paragraph 5, my lord, I've said, my lord, this is the date of communication, and this is when I've given the objection, my lord. Paragraph 3 and paragraph 5, my lord.
Yes, how can you? No, sir. If there is a policy that you will not renew unless the consent or approval of the Gram Panchayat or a Gram Sabha comes, then you can't.
Regarding this, my lord, you have to take instruction.
What instructions? There is a subsequent one
Will
where
not-
you, by way of a reference or incorporation, you have imbibed that policy into it and reiterated in the last sentence. No renewal shall be granted.
But so far as policy is concerned, there is no dispute. But so far as this notification when it was received by the Gram Panchayat, because 13/1/25, the 30 days period expires on 32/25. And so far as the objection, if your lordship will see, that is at annexure 2. May I take your lordships to
Why you circulated or served the 13-1 resolution on 31st-1? Why?
that
How do they came? Suppose on the last day of 30 days you said, that's on 29th day or a 30th day. Does it mean that this timeline of 30 days is a farcical approach?
And all the surpluses in that area, and so far Basantpur is concerned, it will receive by the executive office.
regarding that only I take instruction when it was notified in that
That is
area.
your own document, sir. And the date is given on 31/1. And the 30 days period will start from the service.
For the service.
From the service. Under section
It's 27
of the
of the Odisha Excise Act.
Lordship may kindly come to page 29.
Subsection 2.
29, your lordship may kindly.
Please, subsection 2.
Page
For the
29.
purpose of clause A of subsection 1, the authority competent to grant license for manufacture, possession, sale.
from the receipt of such reference.
Man,
So it will start from the date of the receipt, not from the date of a decision.
Your lordship may kindly see the last page of that notice. The
Yes.
last page of that notice.
Yes, what it
That is
is.
a memo appended to the notice.
Yes.
On the
No
last
restrictions, sir. When it is received, that is there in at
Memo-
page
memo number.
23.
Well,
Page number 23.
well, regarding this, whether this is a part of this document, because if your lordship will look at the memo, copy forwarded to the sub-inspector of excise Ghatana, 3 Xerox copies of the served copies of the notice from the Gram Panchayat. But this is indicated, the copies have been served on
What is
13/1.
Sir,
31st of January 2025, the copy was served on him.
But that is what they say. If your lordship will look at the last but one page of that notice,
Page?
that is the page 29, if your lordship may kindly see. Regarding this, I need to take an instruction because your lordship will
Instruction.
the last page of the notice, there is a memo number 189,
Page 29.
but the last page of that notice.
translated copy. I think my learned.
No, 29. If your lordship, that notice,
No, I do not know.
Pratama Prastava.
No, the last.
No, this is what he is referring. You are referring this?
That is the
One, not that one, the notice itself. The
what is the
13
page, sir?
page number they have not given my copy. This is 29th page. 20th page of the brief.
Annexer, sir.
2 series.
Says not copy for 2 series is my resolution.
Annexure 1 starts from page 19. If your lordship may kindly see that notice, that is in my lord's brief, it must be in page 24. The notice dated 13/1
to the collector.
to the Basantpur
13/1.
Basantpur Gram Panchayat.
Number?
This is addressed to the Basantpur Gram Panchayat. If your lordship. Notice issued by the District Excise Office, Keonjhar.
23 to 9.
What? What you are reading? Sir, this one you are referring, I am just going, I do not know. Memo number 190.
Yes.
Memo number 190.
189, your lordship.
189. Let us see just above it. Copy forwarded to Excise Ghatgoa. 3 Xerox copies served notice from the Gram Panchayat. 1 copy should be 1 serve should be submitted. What is this Anandapur? Where is the Basantapur? In 189. If the translation is correct, I do not know.
Copy forwarded to the Sub Inspector Excise Ghatgoa.
But that was the page 32.
Served copies of the notice from Gram Panchayat. Gram Panchayat means the Gram Panchayat to which this notice has been addressed.
Sir, this may be memo that the copy may be forwarded, 3 Xerox copies of the served copy of the notice. And then the notice when it comes, it contains a signature of 31/1. The next page at the bottom.
This aspect Mr. Mishra knows very well. The authorities always put the issue number. They never say when it is served. They won't come from a service date.
There cannot be a denial.
Just verify with the authorities.
Saying it's very easy, but there cannot be any denial.
Only that regarding that service of notice.
Nothing has been done.
Let me just take instruction with respect to this only. Because the meeting which was called of the Gram Panchayat, that was called on 17/2.
Of
17/2/2025.
So
then it could not be.
And there was already an objection before that.
No, my lord. 17/2/2025. The meeting could not be concluded. Then it was rescheduled to 21/2/2025.
Question is of an objection. When the objection was filed.
Was received. Whether it is within the
question is when the objection was filed. What is the date of the objection?
The date of objection, Lord, is 22/2/2025.
So
within 30 days.
ଗ୍ରାମସଭା କୁ ପୁନର୍ବାର 21/2/2025 ଦିନ କରାଯିବାକୁ ନିଷ୍ପତ୍ତି ନିଆଗଲା। ସେଇ ଦିନ ନିଷ୍ପତ୍ତି ହେଇଗଲା 21 ତାରିଖରେ 22 ତାରିଖରେ ଫାଇଲ କରିଦେଲେ। objection ଟା
yes
ନିଷ୍ପତ୍ତି ନିଆଗଲା
on 21 that is what the record speaks, man. But so far as the issuance of notice and service of notice, regarding that only I just take instruction. What is that date on which, whether it is the same date or otherwise, well, I cannot improve the record. Only with respect to that, I just take instruction. Your lordship may allow.
Set a receive which 28 ତାରିଖ।
Again, receive copy or OPC 345. Page 24.
No, this is also the 3 Xerox copies of the served copies of a notice from Gram Panchayat or to Gram Panchayat.
No.
Oh.
After service, a copy of receipt acknowledgement has to be returned to the office concerned. From where it is fine.
So this notice was given the government has proposed. The spelling is wrong, not purposed. It is proposed. When the decision was taken for proposal, the first line. Proposed to grant, then there must be a decision of the government. Where is that communication of the government?
Thereafter, there's an extension of the license till the new excise policy comes.
Oh, I'm just looking at it.
And if the lordship of
The
C20.
area comes under pressure.
Yes, sir.
Panchayat extension.
Otherwise, there
scheduled
can't be a
area.
notice under 27. Unless it's a
Panchayat extension of scheduled area.
Schedule Area Act that has been, my lord, incorporated into the after 1996, my lord, into the schedule areas, the panchayats. My lord. And that's how, my lord, PESA Act comes. And one of the clauses of PESA Act, my lord, that the state government has to formulate the principles or laws to prohibit sale of liquor. The lordship could permit me, I can give share with the lordship 2 copies of the PESA Act.
How can it be done? Cannot be done. The question is 30 days period. What they have done.
It's not the relevant.
It's correct.
The PESA Act,
No,
see section 4.
let them take an instruction. This can't be. What he says appears to be correct on record. 30 days time is mandatory. They have first conducted the meeting on 17th, that is after 30 days. And then again postponed on 21st or they have done it. And 22nd, the objection. So they say within 30 days objection, they said after 30 days we have decided. The question is essentially when the service was affected.
The OP number 5, wherever the license has been issued. Notice has also to come to him also. Subject to minors, is the party.
We will not delay it. You come first, you show, then we will. First you come and show when what is the date, effective date of service, of notice. That's all. If it is 13, they are out of 30 days. If it is 31st, then they are within 30 days. Then is only question which has to be decided.
My lords, item 23.
What?
My lord may permit service by Dusty because the department has given an inclination that they will pass an order and therefore the petition would be rendered in front.
What are you talking about? 23 we have taken.
Yes, my lords may just report that petitioners are directed to serve by Dusty. 23.
Who is appearing in 23? Yes, what is
multiple so forth notice matter?
That's all.
Yeah. And so my lords, the only request is
he is appearing.
Yes, my lords, but the officer.
What does he? If he waives the service and says that I am appearing for all the respondents, what more does he?
He will be intimating, sir.
He is intimating.
I was directed to obtain instruction. Let I need this time because the superintendent of excise is sustained an accident at the time of enforcement. At the repeated time.
Particular provision has been misread by the officer lordship, that is 42(1). It is never a transfer. With administrative correction of only some names. And it is after order of the collector, which has been dealt with the proper procedure of law, and without being any authority, has lordship issued this slash. That's why.
It is unforeseen circumstances. If we had met with the extreme note,
The stay person that order so that it will suffice lordship.
it is not going to affect right now. I have seen the nature of the order.
But lordship, I am
Come on the next. Yes, on the next day. Come.
Item 34.
lordship next please.
Yes, an acquisition is sought.
In this case, official notice of CSP withdrawal of license petitioner
Last occasion, Lord directed me to file an affidavit so that to incorporate all the documents which I submitted and the earlier occasion, and submit the affidavit here. The documents which I had submitted the case in the record.
Copy given? What is this confiscation?
The whole case is that the confiscation proceeding is to be initiated by the superintendent of excise, not by one officer in charge of his excise police station. The sole contention is that the appeal was entertained by the superintendent of excise, but order was passed by the OIC. Now I have filed these documents, I have annexed the copy of the order passed in that confiscation proceeding. That is passed by the superintendent of excise. It was communicated to her, and knowing that this writ application has been filed and for
That document.
that's it. This confiscation proceeding summons she received. Yeah, and
Page 13.
The summon is issued to appear before the superintendent of excise.
Yes, page 32. That was the summon, and thereafter the
No, the page 13 is a summon. Issued by authorized
Authorized officer.
superintendent of excise.
I'm
Section 71 proceeding.
I'm in the writ petitions.
Your counter will see.
Yes, that is page 32.
13.
Yes. This summon was issued by the superintendent of excise. Director Lordship kindly down to page 17. The order was passed. And Lordship kindly come to page 12. Pursuant to the summon under page 13, she appeared through an advocate, learned advocate.
Section we have. Yes, so superintendent has said that it appears that he has applied to some other area with her knowledge and consent, without any valid document. So that was passed on 26/9/25. Then?
Now let's kindly turn to paragraph 11, paragraph 10 and 11 of the writ petition. That is the whole case of the petitioner. Paragraph 10 and 11.
Of the
writ petition. That is at page 8 of the writ petition.
That is the ground. So they have said that it can be passed by the superintendent, not the OIC.
Yes.
But you have shown that it is OIC, it is the superintendent who has passed the order.
Passed the order. And Miller Clerkship, actually, it is their case that Miller, they were not given any opportunity of hearing Miller.
But it appears from the proceeding, the orders passed from by the superintendent that they were given. And they were represented by the lawyer.
Page 12, Miller. Page 12.
But it was filed.
Yes, and the ground is viral fever. But in the writ petition, they have stated she was on pilgrimage.
Really, the petitioner was on pilgrim.
I do not know your lawyer that you can't deny this particular document. And you have said that due to viral fever, the petitioner is unable to present. And that was 12/9/2025.
My lord, that didn't only she appeared through that advocate, and the other date she was not communicated with.
What communicated? And the order was passed subsequent thereto, 12/9. Wakalatnama, what are you talking about? See, Prashanta Kumar Mahanti, who is he?
I am Prasanna.
So you file a Wakalatnama?
It is read petition.
No, before the superintendent.
12/9/2025 clearly written. Your name,
Clearly your name is written, sir.
all the days.
Page 16 of the counter. Your name is given, Prashant Kumar Mahanti, advocate, filed Wakalatnama on behalf of the EPA. The Wakalatnama submitted is accepted. Allow 7 days time to file representation.
And denying this, you have received the counter.
Page says.
You have received the counter copy. You have received.
Only once the petitioner was replaced.
Sir, Wakalatnama means that you have been authorized to appear before the authority for all time to come in that proceeding. It is not a Wakalatnama for each day.
The other dates.
Other dates were fixed in your presence, sir. On 12/9, they fixed the date on 19/9. On 19/9, they fixed the date on 26/9. And then on 26/9, the order is passed.
Order has also communicated to them, Annexure D by 3B.
Absolutely. Correct. And that was granted. 7 days time was given to file a representation. No, sir. They're challenging the auction notice or what? And you are challenging only the auction notice,
Yes, ma'am.
not challenging the orders passed by the proceeding by the officer. What to do?
That order passed at page 24. The
Look at your writ petition. Look at your prayer. Please come to the prayer. Please come to the prayer. At page 11 of your writ petition. What you have prayed. Sir, tell me, what is the prayer?
The petitioner prays that Honorable Court may graciously please to admit this writ application, call for the records of the authorized officer come Supreme of Exchange Khordha, and after hearing the parties, quash into auction sale notice.
So auction sale notice you are challenged.
And further we please to pass up.
What about the order of the superintendent directing the confiscation and everything, adjudication has been done? This order is staring at your face.
My lord, this order was.
You have concealed this order 26/9.
No, my lord. It was not in my knowledge.
Cannot be, because they have shown that it was duly communicated. It was duly communicated. And it also shows that it was communicated through WhatsApp, and there is a blue tick. What does it connote? Blue tick?
That WhatsApp number never belonged to me. I do not know. Nor it was
Your client.
Other client might be.
Might be other client.
Her
The
son,
other
who is
four persons are there.
her son, who is the opposite party number 3 in that confiscation proceeding. The son is the lifting agent.
Not so easy, sir.
My lord, the petitioner.
Sorry, we do not accept. We do not accept your. Nako. The instant writ petition
So let's see, it is
Refund
here. On it.
done.
We have to file an amendment. It is also a Supreme Court judgment.
Your Lordship, the prayer is at page 14. And we have done as per prayer.
Your Lordship, the sole contention of the petitioner is that if the petitioner wants the interest and refund amount from the date of deposit until the date of refund.
What is this memo? What is the legality of this document in a court proceeding? By way of this memorandum or letter, can a court amend the petition? Tell me. I do not know. I am a learner. I do not know. I just want to learn, because a person should not remain ignorant throughout his life. He must learn every day. So I am ready to learn. Tell me that amendment will be carried out or will be allowed by the court on the basis of a letter written by the advocate. A verified petition followed by an affidavit will be amended by the basis of a letter of an advocate. Tell me, sir. I do not know the procedure.
I want to cite a Supreme Court document.
That it can be done by virtue of a letter. Show me a judgment. I said I am ready to correct myself. That the court will permit the amendment. No difficulty, sir. Which paragraph?
Para 16 on page 2.
Yes, sir.
Mr. Counsel, when the statute provides that an application has to be made for.
Sir, I am on an amendment, sir. You have sought for to amend the petition. I am just seeking your advice or your assistance, whether on the basis of a letter which is signed by you as an advocate, can a writ petition be amended? I am asking. Settlement is different.
We will find the amendment.
Lordship, this order which we have passed here, Lordship, it is revised. If after all he has agreed against this order, let him file a revision before the commission. Your Lordship, because the law is well settled, Your Lordship, and the statute we have granted as per the statute. Your Lordship, if Your Lordship will permit me, I can.
Can you grant beyond the statute?
Exactly. So as per statute.
And are you always sure that you have always done the things as per the statute?
And then, Your Lordship, in this case, why Your Lordship? Because pursuant to Your Lordship on the last occasion, this case was listed, and my Lord has observed that you have the interest is to be paid, and I admit that interest is to be paid. No, Your Lordship has observed.
Just remind
Your Lordship,
full bench decision of this.
Your Lordship, Your Lordship.
Up to 90 days after filing this refund.
Exactly. He is repaid. Your Lordship, for a moment,
that first day onwards.
For a moment, he is represented. He has admitted everything.
The original case is the Raman's case of the Supreme Court.
Your Lordship.
That was in relation to the application for equity shares.
Your Lordship.
Now the things have changed because of the rules. There, it used to be like given through a check in cash. The equity shares not allotted. And thereafter, the refund of the money is after 2 years, 4 years, and the company utilizes the amount. Then the question that matter came before the Supreme Court. Supreme Court said that you can't. If you have declined to allot the equity share on the basis of an application, you can't keep the money because this is not your money. Then if you do not, then he is entitled to an interest and directed the interest to be paid on those amount. And this really originated here from. So there they fix a date of 30 days from the date of the initial allotment or decline to allot, that you'll have to refund within 30 days.
Here section 14C says.
Now the SEBI has changed the rule. Now the company does not utilize the money. It is only blocked in the account. That amount you cannot utilize. If it is allotted, automatically it is debited from your account. Just to avoid the interest. So what to do?
Here the provision is very clear. Section 14C of the OST Act clearly says that we have to grant refund within a period of 90 days from the date of his application.
And 10% interest.
Your Lordship, we have paid. Your Lordship, 90 days, after 90 days, the remaining days, ideal interest.
Sir, to take this stand, CSTO Orissa Amendment 6/7/2006, the restrictions are pending. You have taken contradictory. You have taken contradictory.
It is his application.
Office used to it.
Your Lordship.
Local sales tax.
Your Lordship.
uh,
Your Lordship. I will know.
no, that means general sales tax act.
And Rule 22, Rule 22.
Definition. Section 2 that defines use of brought forth. You means Parliament has brought forth the statute, amendment in the statute from 1/4/2005. What is general sales tax?
Your Lordship.
Under CST Act,
My.
saying that VAT.
Your Lordship. Your Lordship.
So how can you say, even though your subordinate legislation has amended CST Orissa rules from 6/7/2006, the OST Act will apply?
Your Lordship, we have not,
Section 9 to you are
Your
contravening.
Your Lordship, we have not said anything. We have
You have
accepted
said
his,
this.
we have accepted his
Sir.
government.
The potency is extracted here.
Your Lordship.
And what is
Your Lordship,
the language
kindly
required by
look
your
into
officer?
look into page 57 of his application.
You have
Your
read this,
Your Lordship.
please.
Your Lordship.
Read this. This refund is related to 2005 6.
Your Lordship.
So which law will apply? OST?
Your Lordship, actually what happened?
Later.
I get
Then
rule 22.
Please clarify, sir.
Well,
Will OST apply?
no, 2005 that is there.
This
Why?
order will sustain.
Your Lordship,
Sir, this order will sustain.
Your Lordship, let me clarify. Why this order and how this order has been passed to Your Lordship. Page 57, his application, Your Lordship. His application, we have allowed his application. In his application, he has quoted not only that, Rule 22 of CST Orissa rule, Your Lordship. Rule 22.
Sir, refund petition or refund claim.
Your Lordship.
The substantive claim, sir.
Your Lordship.
Sir, Rule 22 is only machinery.
Your Lordship, it is the machinery, but the provision, so far as
Then
the
VAT Act is silent.
Your Lordship,
Then only.
VAT Act was silent. Your Lordship, this VAT Act,
Silent with respect to refund. Most never.
Your Lordship, for a moment, 22.
Applicable law, sir. What is applicable law? I'm on that. You are granting refund under 9(2)
Your Lordship.
of the CST Act.
Your Lordship.
Please see.
My Lord.
So when section 2 of the CST Act has come into force, the general sales tax law, definition of general sales tax law. Not from 6/7/2006. Definition of
Again, 9(2).
when has it come? General sales tax law definition.
Your Lordship. The general sales tax law, 2I. Your Lordship, interest, mutadis, we have.
Sir, assessment order. Taking into the returns were right. Which returns you have assessed? 5/6.
CST returns.
CST.
Your Lordship.
5/6.
Your Lordship.
What was it? At that. Returns are filed under which law?
We file.
When VAT
Your
was
Lordship.
enforced.
Your Lordship, those
So refund clause.
Your Lordship, so far as the interest, since CST, there is no interest provision under CST Act. Your Lordship. So mutatis that rule 22
does not speak
of
that
CST Orissa rule applies, Your Lordship.
Section 9(2), what will you do?
9(2), Your Lordship, so far as the general sales tax law, Your Lordship.
Rule 22 is not for that purpose, sir.
Then
You are misreading 22.
Then there is
We bring an amendment, this can't be done this year.
Your Lordship, also, Your Lordship, from the last week, this case was there. We have done it hastily, I think. Your Lordship, so let me go through, if at all, I can, Your Lordship, we can modify this. Why we have done this mistake, Your Lordship, let me admit, let me concede, Your Lordship, to some aspect. What my Lord has argued. Let me concede one aspect.
I think read by Viral sir and Mr. Acharya is also there online. So, Mr. Acharya.
Perhaps your lordship will kindly have your lordship's last order of 27th November. My lords, it is that issue with relation to WMT and DMT. My lords were pleased to hear this matter, and your lordships had kept this matter today only for filing of the written note of arguments.
So please submit the arguments.
Yes, my lords. Your lordship, we are filing it today, my lords.
I have already filed my petition.
You have, well,
The cause list indicates the customs department has already filed. My lords.
Along with the list of sites.
what is this one judgment?
That we have referred in the written note, however, it was referred, but we have missed out in the copy, so it's there, just for the reference. It is there in the letter.
And where is yours? Written notes of?
Filed online.
Right. Give me a copy.
Plus, the written notes is at flag B of your lordship's brief, filed by the customs.
The difficulty here is that when we start dictating the judgment, we do not have that advantage of this PDF. So we have to go by a hard copy. So is hard copy duly notified. So it will be better for us. So flag B, flag C is very difficult to find out. So let us examine, because on a lighter note, not connected with this, don't take it as our final opinion. It is just a humor on a lighter note. The old, the adage that has come in the judicial parlance is this: more voluminous the paper, less notes of submissions.
Item 37.
Oblige, please.
Yes, I got to kindly remember the other day, my lords. There's such a mitigation. My lords, I directed French get instruction on this, my lords. The entire tax is paid, my lords.
Not instruction, to take pragmatic view.
Pragmatic, right? You have remembered. There are 148 AMJ non that the provision, my lords. That says that if you pay tax, my lords.
So let me compliment that. Let me show my pragmatic view.
You carry it.
No,
Only I am authorizing my lords. To refresh my lord's memory. My lord's memory is very, I know. So, right. Are you right? Here, that's the summary only. I don't strain my lord's time also. That's what has happened in this case. Also, I remember as a matter of litigation policy, government want to reduce litigation and has introduced lords 148A. 128A. 128A precisely speaks lords. Yes, any demand which is there in the liability, electronic liability register, either arising from out of statement, notice, or order under Section 70. For initial period of 3 years, not thereafter, because there are technical snacks either by department and for the revenue compliances by the litigant. All this to get to do away with all this. For initial 3 years, 17, 18, 19, 19, I am for 17, 18. The initial first year.
that if I pay the tax, the interest and penalties are waived plus, and a mechanism put in place. And manner of payment is there in Rule 164 plus. And 164 to precise specs. And whatever may be the manner of payment in respect of constituent bills, demands in the statute bills, it's a non-obstacle.
I understand. On
Yes,
that
yes.
day, since you have not reversed, you have
Yes.
paid it, so you wanted
Yes,
to.
yes, that says only.
That's a technical
Technical
flaw.
Let your lordship only difficulty is that there is a demand of 32 lakhs, your lordship, tax. So plus the interest and penalty, those have to be waived, your lordship. So out of 32 lakhs, your lordship, 1,36,000 is a IGST RCA. So that cannot be deposited through credit ledger. His dispute that cannot be deposited from credit ledger, it is our dispute. It has to be debited from the cash ledger, your lordship. But inadvertently or anything, he has deposited from credit ledger. Balance 7,95,000 he has deposited from cash ledger and balance from credit ledger. On the last occasion, also my learning senior agrees that if your lordship will it, he can deposit that 1,36,000.
136,000.
1,36,000 that are same amount from cash ledger, from cash, your lordship you will deposit. And I have objected that it cannot be, there cannot be any direct
Done after such a long time.
your lordship. So in this peculiarity, and since your lordship has viewed that pragmatic view should be done, because out of 32 lakhs, only for
Substantial amount has already been deposited.
but that is I have discussed with my officers. So if your lordship can direct, he can deposit that 1,36,000 from cash ledger. And the peculiarity is that since the entire amount prior to the date of publication has been deposited,
yes,
and the application was in due time. So everything was in due time. So for that reason, so let him deposit as in a peculiar condition.
And
let him deposit.
Condition also, appeal is also withdrawn. All those compliances are there.
How soon?
I don't add anything except saying, no, I am not adding anything. The only the
Mr.
is fair enough.
What my lord is querying is
How soon you will deposit?
As your lordship director, I am there not comply. Only plus liberty.
know that bona fide, then we can.
That your lordship knows. Any date your lordship director, only liberty bills.
You deposit by Monday,
Yes.
and we are keeping this matter on
Monday
itself or Tuesday itself.
To make concession for betterment, concession may not be required.
We will take into consideration and ask.
And only one liberty bills. Because now there is double deposit.
Sir, double liberty is not required. On the day of deposit, you claim a refund application, file a refund application, that much of amount will be credited to your credit ledger.
Only a line expect for my lords to be there.
So what I can do, my lord,
I accede. You as per lordship direction, he is really taking a very pragmatic call. I not sir.
Sir, I have already discussed with the department.
We are all.
So you should rest your case.
We are all in safe hands of standing.
May I pray one thing first? So instead of Monday, I will be communicating. Let it be on Thursday. Item
It's
one.
all like nothing is done. Nowadays everything is electronically done. So there is no difficulty. Today is Thursday. If you come.
I just on I just deposit
Cash.
cash.
Just ask these
Let me-
paragraph order. Just to show a bona fide, let him deposit that.
Thursday minutes,
By
item
Monday.
one. Before that, I will make the deposit.
No. By Monday, Tuesday we are keeping.
Miles.
We have to respect the stature of the arguing counsel. So he can deposit within 5 minutes. It does not require much time. He can deposit within 5 minutes. This amount is negligible.
And since negligible, your lordship is passing the order. Since negligible.
No, he is unnecessarily imposed with the penalty and this one, which is use.
Now, this penalty you should.
Tuesday.
Item 38.
Deposit by Monday.
Yes.
By Monday, yes, absolutely.
Yes.
Yes, please.
38.
No. The appellate had this application, challenging the order on judges, Nation 9, has confirmed the order for appellate authority, that is sub-collector, Nation 8. And Lord has said, rejected my application on the ground of limitation of 1.5 months.
Limitation means
Means, my lord,
delay in latches.
but it's only, but my lord has directed Anisha 5 is the order, initial order. That I have to find
Just
out
wait.
within this such time. That is, Anisha 5 plus 24.
Oh,
I think sub-collector within 2 weeks. You don't have the petition. Yes, I have a question. You don't have the petition.
where is the application for condonation there?
Yes.
For the collector?
Yes, sir.
I mean sub-collector.
That has been admitted and place petition. Place petition.
47.
Yes. It is the perfect.
Just one. Sir, I am talking about your application for condonation before the sub-collector.
Is that is
Where is that application?
yes. Yes, Miss Queen. I'm not honest that, but since
Please show us if you have a copy, sir.
yes, one copy.
It's a correct English word.
I can challenge on the ground that when the assessment as said to have been passed under 135 of the Electricity Act 2003, directing the petitioner to prefer appeal under 127. Your law is well settled that the assessing officer must verify
It's a case of
assessing
it's a case of a pilferage.
on the allegation that
It's a case of a pilferage.
yes, Miller. On the allegation that there is
So there was a preliminary assessment order, then the final assessment has been done.
no
No
preliminary assessment.
No preliminary assessment.
Miller, assessing officer power is under section 126 of the Electricity Act. Your Lordship may see the language is on an inspection of the 126 says on an inspection of the place and premises, if the assessing officer comes to the conclusion that there is business obstruction of power supply, then he may proceed under 126 to pass a provisional assessment order, and that is in a prescribed format having 15 points to fill
So
up.
that is what I asked, whether he
He has not followed that. First question is, Miller, he was not there in the verification. The verification.
How do you know?
From other persons.
How do you know?
Lordship may see the verification report I have annexed, Miller, and in my objection filed before the assessing officer.
Has he also lost the FIR with the local police station?
They have not lost, Miller. They have proceeded under 135. Miller, 135 is the offense of theft, and for that special court is constituted. Milord, under section 154(5), the special court's power is there. 154(5) says that when if the so far the theft of illicit.
No, I understand. I simply asked the question whether they filed an FIR or not filed an FIR.
No FIR has been
No,
filed.
that's all. That's enough. That's enough because it is both the civil and the criminal liability.
Yes.
So I just wanted to know whether both have been exhausted or not.
No, Milord.
So they exhausted the civil liability.
The notice issued under Annex 2 series, page 15, Milord.
Yes.
Notice under section 135 of the Illicit Act. They raised a demand under section 135 of the Illicit Act. Page 15, running page 15, Annex 2 series, Milord.
Yes.
Milord, on the top, notice under section 135 of the Illicit Act 2003.
Correct.
Read with the regulation 163, and in the bottom also, Milord, in the last line, Milord, this shall be treated as a final. This notice is being given to you under section 135 of the Illicit Act 2003.
True.
Milord, even if this is issued, the consumer filed his reply, Milord, and no final assessment order was passed within 30 days. 160, 126, 3 says
Yes, why the single bench has rejected your prayer?
Milord, what happened, Milord? There was a first repeat petition filed. Time was under disconnection. The Honorable High Court said, single judge said that you deposit 25% of the.
Where is the impugned order?
Impugned order, Milord, Lordship page 32 starts 32 and the relevant portion is 34 and 35, Milord. Milord, may I place this, Milord?
I do not find this 32.
Since the final assessment order has been already been made, passed in case at hand, on counsel appearing for the petition, the permitted to the appellate authority challenging the final assessment order by depositing the rest 25% of the demand. Your Lordship may see the final assessment order, what has been passed, Milord. I have annexed that at annexure. Lordship may annexure, page 24, Lordship may see.
Petition, sir.
Milord.
Good night.
Milord, my read petition is Milord.
No, thank you. Prayer.
Milord. Milord, I have taken all those grounds.
Give me a.
Yes. Yes.
Sorry, just refreshing the memory regarding this act. Yes.
Yes, Milord. Milord, 126 says that if the assessing officer on an inspection comes to the conclusion that there is pilferage or theft of illicity, he may proceed as per law. Assessing officer power is under section 126. He has to issue a provisional assessment order, inviting objection to be filed. And so when the objection is filed, Milord, within 1 month, he has to pass the final assessment order, giving an opportunity of hearing. Milord, so far this case is concerned, the assessing officer, first of all, was not present on the verification. In the verification report, he has not signed, Milord. On the basis of inspection report submitted by some of the outsiders, he has issued this letter, Milord. I filed objection before him. You have got no authority to issue such a letter under 135 also. You are the assessing officer on 126. You cannot raise a demand under 135. And you, Milord, my objection is at Annexure 6, Milord. Then Milord, what happened, Milord? He raised me a demand, Milord. No opportunity of hearing was given. And no final assessment order was passed within 30 days. As per regulation 165, Milord, if the assessing officer is, when the objection is filed, the provisional assessment order is to be made final within 30 days, recording the what he has stated in his focus.
Within 30 days, he does not. Then what is the consequence provided?
The consequence is regulation 65 says if the no final assessment order has been passed and served within 30 days of service of provisional assessment order, then such order shall be null and void.
Which order?
This whatever demand they have issued.
So you can raise this point by going to an appellate forum. There is a forum of an appeal provided under section 127
if the
against an order passed under section
Milord, if the order is passed within 30 days and under
Even if
one
a order,
under
if a order is a
127.
nullity, if a order is a nullity, then this, unless it is declared as a nullity, you have to approach before the prover.
Milord, when it
For
is
having
not
that
passed,
declaration.
when
that
it is not passed under the appropriate provision of law, appeal is not maintainable.
Why not?
Milord,
If
if
the
it
no
is,
final assessment order is
no, if it is passed under 126, then my right of appeal is under section 127. Lord,
it is under 126.
No, Milord.
Then
Lord,
under what provision? Then whether these rules of 30 days applies.
It is
If
there.
it is not under
It is,
section
Milord, for the sake of argument, I said,
can that 30 days period apply?
Milord, so for the sake of argument, I said that even if it will be treated as an assessment under 126, then only.
So this is
appeal lies
provision.
Appeal lies under 127.
What is another provision assessment?
120
of a quantity of the pilferage.
126, Milord.
That's the only way.
Only
Judge
way.
assessed and directed you to make the payments. Whether
there is no assessment
at the time of search, at the time of interception, whether assessing officer, the officer designated under section 135
has not
was
verified
there or not. These are the points you can raise in an appeal under section 1.
I have
Once the final
Milord,
order
once,
is come
Milord,
under section
well,
1.
Milord, the order is a nullity, Milord, and the assessing officer
It's a
has not.
declaration. Unless the order is declared as a nullity, can you say there must be a conscious decision?
Milord, on the face of record, it is a nullity. Milord, he has
by operation of the law, it becomes a nullity, but it was not a nullity.
Milord, on the 135, how he is authorized to issue such a notice on 135?
You can take that plea before the appellate forum.
Milord, if they are not
entire 126 proceeding originated from the inspection under section 135. If the officer was not competent, then this 26 proceeding should also fail. Milord, take that plea.
Milord, when the appeal is not entertained by the appellate authority under 135, Milord, there is no need to approach.
There is no provision for an appeal under section 135, sir.
127, Milord.
Correct. 127 says any order passed under section 126
is
appellable.
Not any order, Milord. Order passed under 126 is appellable.
That is what, sir? Now, question is, order passed under section 126. It contemplates both the situations, provisional and final.
Provisional. Both the situations means so far the 135 offense is concerned.
Sorry,
135 offense, Milord. You also may see when 165 says that the order has become null and void.
What? Assessment order.
Sir, I am challenging.
You are challenging the final assessment order in the writ petition. I am thankful to my brother that he is very meticulous on the papers.
Sir, Lordship, kindly see.
But
Sir, this is the notice under 135.
now
This is the notice.
this is an order which is passed under section 126. And if the court has come to a finding that this order is staring at your case, then your right to challenge this order is provided.
Lord, it must have been passed and sought within 30 days, my lord.
Sir,
Go there before the appellate authority.
Lord, I am will be put unnecessary burden to deposit 50%, my lord.
That is the
And
main
whatever
issue.
mistake they will
I
commit, my lord.
understood that. I was just waiting that you will
No,
come
my
with this.
lord. My lord, why they will commit the mistake and take advantage of that, my lord. Your lordship may see. Dated 17/9/2025
yes.
of the Honorable Single Judge.
He's challenged it.
Sir, in writ appeal,
How very.
that is what I am saying. In writ petition, you challenge the notice. Section 130.
Demand notice.
During the pendency of writ petition, the final assessment order has been furnished by the council.
Without hearing me, without giving an opportunity of hearing.
Please,
In my absence.
please, sir.
Yes,
Let me,
that is the most requirement.
let me
We will
express.
give you a requirement. We will just listen to my brother.
I'm sorry.
Don't worry.
I'm sorry.
There is another requirement you will get it.
My lord.
What he says. Yes.
So, during the pendency of the writ petition or at the time of hearing, the counsel for the opposing party furnished to the court the final assessment order. Right? That is taken on record, but there was no challenge to that in the writ petition. So, learned single judge has said, go in appeal since now final assessment order has been passed. Obviously, that is under 126. So, you have a remedy under 127. Right?
My lord.
So, now you are coming forward in writ appeal.
Challenging the final assessment order, which you did not challenge in the writ. Can you do it?
My lord.
Now this is a requirement I want.
Under what situation they
I
have.
am asking you, sir.
Yes, my lord.
The appellate court will be substituted
Lord, I-
itself into the original court.
I will satisfy your lordship. I will satisfy your lordship. My lord, when this annexure, that is annexure, lordship may see.
Sir,
When this
I believe
annexure,
the law is well settled
Sir.
in this regard.
My
The
lord.
law is well settled in this regard. Sometimes we have to,
Sir,
we have.
your lordship may see.
Yes.
Lordship may see. What was solved to us is page
It is
24.
apparent from
Sir, if you are accused by that order, challenge that in writ petition.
My lord, sir, it a situation del tike kind for the moment your lordship may hear.
Sir,
Sir, when this was the, he said that this is the final assessment order, and the honorable single judge observed that this final assessment order is not available in the record.
Sir,
If they have solved it, my lord, if they have passed it on 35/2025,
I understand.
what prevented them to solve it, my lord? Then on the next date, my lord, he solved this.
But I can speak Bengali more. Can't speak Odia.
Sir, when the law, honorable single judge made a query that where is the final assessment order, which was not solved on me, my lord.
Sir, kindly consider when the court found that the basis.
Sir, how can I prefer another appeal, my lord?
The
When
basis of
honorable
the
single judge.
126, basis of the 126 has come up. You were challenging the foundation of 126. He says that now this foundation has now turned out into a castle. Once the castle has already been built, we are not going to touch the foundation. You can challenge before the appellate court. Now, if the court refused to exercise the discretion under section 120, under article 126, will the appellate court interfere with the order of discretion? It is a discretion of the writ court to permit the writ petition to be continued or may relegate the parties to explore the statutory remedy. You can take a plea of nullity. You can take a plea of infirmity. You can take a plea of illegality. You can take plea whatever is available under the earth or over the earth or under the sky before the appellate forum. Go and challenge that.
Milord, they are not entertaining if the order is passed under 135. And Milord, one thing, Milord, so far
this final assessment order,
service is concerned, Milord.
It has said that you have a right of an appeal under section 127.
Milord, at what juncture it has been solved, Milord. So I only to one place this thing, Milord. Milord, when the honorable single judge has to.
Then sir, the wheel of cost will reel fast. If you do not understand, then the wheel of cost will reel fast. You can continue. We will not prevent you. You can continue for hours. No difficulty. So you are not realizing that what troubles us. You are before the appellate forum. Please consider the writ petition. If there is an alternative remedy, it is the discretion of the writ court whether to entertain the writ petition or he can relegate the parties to the alternative forum. He has exercised the discretion. Whether the appellate court should interfere with the discretionary order, what is the law? Tell us. I'm asking you this. You are not telling them what can be done. You convince us. You are stick to 135. 135 is a criminality part. What about the civil part? Civil part is distinct. You are aware, it appears to me that you are a regular practitioner so far as the Electricity Act cases are concerned. You know that theft of electricity invites both civil as well as the criminal liability. Both can run simultaneously. I can give you a lot of judgments on that. It is all distinct.
What power under one?
Again, I'm saying, if the wrong exercise of power, you have a right to challenge it before the appellate forum. So you are taking me back to my days over there to argue on behalf of the parties. It is an order, final order, which is under section 126. 135 does not invite any quantification of the electricity consumed or theft. Does it invite? No. 135 is silent.
Milord, the notice have quantified the demand.
Or that if the wrong section is quoted, if they want to proceed under the correct section, does it mean that the entire proceeding will go? You know the civil liability. You appeared. And you visualize the situation. He has relegated you. Go and file an appeal. Still, your right is still there. While you are I think losing a time when this order is passed. And what is the period of limitation provided under the
limitation lasts 6 long, and the Lordship will not indicated the limitation within how much time I will prefer appeal, Milord. Now they have issued a demand notice, Milord. Milord, in the statute, Milord, there is a limitation is 1 month. But final assessment was solved, Milord, after a long lapse of time. They solved me in a court, Milord. When the court directed, when is the final
sir, then we will definitely record that when the service has been affected on you. So just for the purpose of computation of the limitation.
Milord. On me the day of a disposal of the writ petition.
True, we'll record that. That it was never served, it came to your knowledge on such and such date.
Your Lordship may simply permit me to withdraw, granting liberty to prefer appeal method within a.
That is what is granted by the single bench, sir. What more the single bench has done? This is exactly what the single bench has done. He has simply requested you to go to
The law requires that it must be solved within 1 month from date of provisional assessment order, and it was solved me Millard in 2025. That is why I have
why you go there and then.
simply I am permitted to withdraw to prefer appeal Millard.
That is all done.
There is no time limit fixed, my lord. They have issued a notice, my lord, to discount the power supply on 25th, my lord. My lord, in that notice, no time limit was fixed by the Honorable Court. But they have issued a notice. From today, my lord, within 1 month, I will appeal. My lord, what happened in the final assembly? If you will be given an opportunity, that amount must have been very, my lord.
I believe in a writ jurisdiction or a civil law, there is no concept of mortem. The judgment has already been delivered.
Two is timing.
I have a strong reservation in this regard. When a limitation is provided, we cannot extend the limitation beyond the statute.
No, when the limitation lapses, they have not solved off. They have filled my limitation.
I understand.
Yes.
But that's why I recorded that you have been served with the copy of CCTO.
And within how much period I will prefer appeal, that was also.
That is up to you to apply your wisdom.
And Lordship, that period of any.
One of the matter I have deprecated.
There's some time.
No, rather we deprecate. No, we cannot compel the authorities to act contrary to statute.
Permit us to prefer appeal.
That is already published. Yes, for the
Item 40.
Item 40. My learned friend has served me a copy of counter affidavit.
Long back.
I'll file long back he has served.
Long back.
I have received the instruction to file the reply. Lordship may call it on next Thursday. In the meantime, by Monday I'll file my reply. By Monday I am filing my reply.
My lord, on the face value, even I don't press it, my counter, on the face value, my lord, it may be done.
Look, he is not pressing the counter. What is the order which is under challenge?
The order of the
26/9.
Yes.
26/9/2025.
Yes.
This order is passed in your matter or in a batch of matters?
That's
Did you submitted your property details statement by 20th September or 21st? So why you are a aggrieved person, sir? I'm surprised. I think the Red Court has granted you a relief.
Relief. That they
Oh,
have.
he's a sorry. I thought you are an appellant.
Yes.
Wrong in it.
There is
And it is concession by you. You conceded.
that is what I am saying.
I think so. He's the appellant. So that's why
It is not there.
he is standing on the appellant.
No, he was mentioning, that's why he was mentioning his case to be taken up so that he can get.
Oh, I just thought that he's the appellant. I was surprised. No, I know.
So here,
This ability not maintainable.
Who appeared?
This.
Mr. Emran Mohanty.
Yes, I
Conceded.
do not dispute
Yes,
that.
they have fairly considered that if the last date has been extended, then if they have already provided the details, you may pass an order for direction.
No, well, what has happened, I'll try to find.
So why you are so jealous?
But this
You want property statement to be uploaded by them. in order to assess them, I think their performance, that is the CCR.
Yes, CCR is there.
So-
So property statement is a requirement under the statute.
That is what I'm saying. If you have extended the time till
But-
26/9/2025.
But that is a false statement made by the petitioner before the honorable
time
court.
to
There
time
was
there.
no extension of time.
What?
There was no extension of time. That was the false statement made by the petitioner before the honorable court. As was the order was passed on the very first day. There was no instruction with the state council. So he only said that if they have submitted and the time has been extended, then let the orders be passed, their cases be considered.
Yeah.
But it is a fact that at
Where is the statement which you have made?
the lordship my kindly.
Yeah.
In September, they have very filed outline.
Well, just have a look, the grounds they have
This
advanced.
is the night of the order part was 20th of September. I think WPC number is including that order. This 483. What is the intent?
Since have said that outline you have already, you have submitted prior to the fees, 29. Offline. But that is.
Jealous, sir.
You're not jealous. My lord, from
the grounds
2024.
There was another matter that is you have not challenged this order of 20th of September to.
But challenge, my lord.
Where is that?
There is a batch of writ petitions. We have
No, passed in 2648.
6489 is also under challenge. If your lordship will find, yes.
They are the different batch. This is another batch.
But all the writ appeals your lordship have tagged together.
Here, which one is 26?
But that is
Where is that? 26489.
26489, that is WA 1613. 1613. So lordship, that is state of Odisha versus Ananta Narayan.
Second one. Yes, ma'am.
That is item.
1613.
There's the third sub item. Third group.
Yes. Folder one day actually. चौधरी देखो चलो
Is there any consequence of provided for particular difference of the property?
Yes.
That amendment,
Yes. That is what I was.
The lordship might have before the judge.
The Odisha Government Servant Conduct Rule, if the Lordship may kindly see, this was amended in 2021. Then your Lordship may kindly see Rule 2, Sub-Rule 4, the next page at page 2, Sub-Rule 4.
Not Rule 2, it's Rule 21, which is in government.
Yes, the Rule 21 was, yes, yes.
One is in.
The amendment rule, I will say,
21, 4 now.
4. Yes, Sub-Rule 4 to Rule 21, amended Rule 4. Every government servant from the level of Group A to Group D is required to make a true and a complete declaration of all his assets, movable and immovable, and the value thereof, as on the 1st January every year, online in HRMS portal on or before 31st January of that year. The declaration shall contain detailed particulars of the officer's assets and must include and specify the assets which are held by him or in the name of his wife, children, and other dependents. In case of female government servants, in the declaration, there shall be a specific mention as to whether the same has been acquired out of her own source or from her husband's source. The return shall be placed in the public domain for access of the public. A copy of the return shall also be accessible to Lokayukta for his information. In the event of failure to file property return in time, the concerned government servant shall be liable to disciplinary action. An employee making a declaration found to be materially incomplete, misleading, or false shall be liable for disciplinary action in a major penalty proceeding under the provisions of the respective disciplinary rules. Besides, up-to-date filing of property return will be a prerequisite for promotion.
While apparent is that it is, this word shall is not mandatory. There is always a reservation. Have you initiated any DP against that?
Not initiated.
So,
but we have granted them adequate opportunity from 2024 till May 2025 to submit the property
so
statement.
that means we have extended the time from January to May.
Yes.
So now they have come in the month of September.
By January 2024 to May 2025, till they submit, despite repeated notice, despite everything, they did not submit. And in the meantime, 400 some odd persons, those who had submitted their property statements, all of them have got their promotion. But we are not after the petitioners, but they were granted opportunity. They didn't avail the opportunity. They didn't submit the property statement. Once it is a requirement under the rule, this rule is this government servant rule. This is made applicable across all the departments. So far as the petitioners are concerned, they want promotion from inspector to inspector. It's a disciplined force matter. And this rule has been made applicable across all the department, including the Home Department. And this notification has been issued by the General Administration, communicated to all departments. It is within their knowledge. Even in the writ petition, they don't dispute that that was not within their knowledge. If your Lordship will find all the submissions made in the writ petition, also they don't dispute that it is a requirement. All that they say, we are in the field job, so we could not know how, when it has to be filed, how it could be filed. So there is a degree. That is the only statement made.
Whether they were communicated of this particular amendment having got
amendment matter, they don't dispute. If your Lordship will look at their writ petition,
whether they have come in the service after this amendment or before the amendment.
Before.
Whether they submitted the property details earlier, only for this year they have not submitted.
But what they have stated in their writ petition, that for earlier years, they don't indicate for which year. Only they say for earlier years we had deposited, but for 2024-25 onwards we have not submitted. That is what they have specifically admitted. But earlier,
difficulty, why you did not submit?
We have submitted person, we have
Why?
submitted
He says that
offline.
from
We have submitted offline.
No, that when you submitted in the month of September 25.
25.
So they have extended from
But-
January 31st, 2024 till May 2025. More than 1.5 year was extended.
No, Milan, for that reason, I have submitted. Our batch, in our batch, we are 602 SIs have been promoted in a day. We are a big batch, Milan. So it is in the year 2017. That is 1, 2, 1. That is 2017. So as for the PMR, police manual, our promotions to the post of inspector shall be that was 10 years. But in the year 25, 24, they have amended it to 8 years, to 7 years. The department has amended to 7 years. Thereafter, now
That is beneficial for them.
I'm not on that. Then for our batch now, they have amended it to 8 years. So our 8 years falls on 2002,
29.
21, 27. Then after
2017.
26 million, and because if it is to 17, then
8 years will take up 25.
25. Then on that day, as per the rules, Miller, our promotion is not 45.
But what about this amendment?
There,
Did you
from time to time, they have made the amendment, they have made the relaxation.
This is the statute, sir. You know better. If it is a law, the law has to be respected. You have not challenged
On
this.
that statute, that was, as for that, we have no dispute. But our promotion shall be on the next year. Because this year it is not coming, so that we are not that aware. Now immediately they have changed. They have changed. They have relaxed the age.
There are two castes. There is another serious panel consequences provided. They have not taken any steps against you.
Only
it provides for a disciplinary action to be taken against you. They have not done. Suppose what your argument is, if I accept, you say since you do not come under the zone of promotion, so there was no hurry in providing it.
No,
but you have exposed yourself to a DP, the disciplinary proceeding to be initiated.
Only for the
no promotion.
No, for that reason, Milord, what we have done, what is their grounds? I'll just have a look at ground. But what ground they have advanced in this petition, in the appeal? Just have a, that is
They say that this is statement made before the court that the time has been extended till 20 or 21st of September.
That is a
incorrect statement.
Where they have in this appeal, what is their government? Where it is located? From the sky, he can make a submission like this.
There must be a statement made on the oath.
On oath. In this appeal, it must be available. Our limited
Sir, if the thing is non-existent, how the documentary evidence of the non-existence will come?
There is
Tell me.
By this honorable single judge, it was a direction to us to submit on the next day offline property statement, and we have submitted accordingly.
That was another case. We have to then examine whether the court can take such a pragmatic view, and court can go beyond that. One has to consider. But in your case also, since you have deposited on 20th, I'm asking you that why you did not deposit earlier.
We have also deposited earlier, but offline. That offline they have not accepted. Only the more.
Only on 20th of September or 21st of September 2025. It is only on that day.
No.
Not before that.
But that was, well, just have a glance.
HRMS.
I understand.
HRMS only on 1st January.
HRMS has been put in place since longer. This is online only.
Only online. Then we submitted, thereafter we submitted
Sir,
offline.
Appreciate that the person may have some kind of a technical, I would say, the restrictions. He may not. he has gone there and submitted the offline, means the hard copy he has submitted. To that extent, I appreciate, sir. But the condition which he is raising is that the time for submission of that particular the property details was never extended till 26th of September 2025.
September
26th of September 2025. It was never extended.
that was they have admitted, Milord.
No, it was you who submitted that it has been extended. Their contention is that my counterpart there, he simply, because that was the first day of admission, he simply say if it is extended and if they have filed within the extended time, I have no issues, you pass the order.
We have,
but he says that was a wrong.
We have filed offline
on your part.
We filed
on your part that it was never extended till 26th of September.
Prayer. What was the prayer in the newspaper?
Was it a correct statement made by you that it was extended till 26th of November?
No, that was the request was to accept our.
No. Please, your submission is recorded, sir. You made a submission that the authorities have extended the time for filing the the property detail till 26 September 2025. That is the today's on the day of passing the order. Then the court was swayed by the fact that since you have extended the time and by this time they have already filed the offline, you consider that.
Which my lord said that
he says that is wrong.
It extended from time to time. They have extended
it up to May 2025. We extended it by correctly.
But that was not in the order.
Sir, 4.2. It is further contended that unless and until the property statement of the petitioners is accepted by the concerned superintendent of police with the due submission of the CCRs along with the said document by tomorrow, 21/9/2025, petitioners will be deprived to get the benefit of promotion to the rank of Inspector of Police for the year 2027. This is the contention of the petitioner. Then 5. The learned additional on the other hand, contended that it is only contention, contended that not admission. Since such property statement details was required to be submitted online and last date was 31/1/2025, not September, and petitioners have not made the same, they are not eligible and entitled to get the benefit of annexure 1. This is what this order says. This is first order. Then the second submission of additional government advocates, it is also contended that if such a permission will be accorded, it will open the floodgate and other candidates will meet similar priority. It is also contended so and so, so and so. Then after considering all these things, 6.1. Therefore, this court, while disposing of the petition, permits the petitioners to submit property statement details offline before the concerned is in course of the day without faith.
Yes.
Then if such statement is submitted,
who have submitted on the.
That is where he is. It is the observation of the court without calling for any response. So it is not their admission before the judge. What is the document to show that it is extended till
September? You submitted in your case, first case you are appearing that it is extended until 26. No. 26 first. Impugned order.
Where is this?
Impugned order it is. Their submission was that it has been extended. Kavita Sardhu.
Sir, it is content.
It is contingent. I'm reading out.
Here to 21/9, this post.
This post here.
So and so, 21/6/489, and that permitted the petitioners there to submit.
No, I was reading an order.
This is the next. Prior. 26, sir. This is 25th, sir. This is 20th.
No.
Then this is 26th.
I'm not, I'm looking in this one. This is that say. This is the Kavita Nayak. This is the your appellant is, who is the, you are representing Kavita Nayak.
Mandakini. Kavita, it is all.
You represent,
That-
you are representing. Please come to paragraph 3.
3. Yes, it is contended that taking into account the last date fixed earlier to 21/9/25, this court by order dated, and this is their circular.
Sir,
Or please permitted the petitioners to submit their property statement of details offline. And for
Before
doing
the
the
consent.
needful in terms of this, so issued. Then come 3.1.
There is the
3.1. No, this is their something.
It is fairly contended that in the bar,
Contended that
the last date of submission of CCS with due acceptance
it
of
should be, it is fairly contended at the bar. Actually, that should be the word. That the last date of submission of CCR with due acceptance of the has now been extended to 26/9. That is what I am saying. It is also fairly contended that in the meantime, the petitioners had submitted their statement details on 20th and 21st. It is accordingly contended that taking into account the extension of time of the CCR to 26/9, so made by the state police headquarters, while its letter dated 25/9, so produced in the court, shall be concerns be directed to submit the CCR accepting the details of the property statement filed on 21. Then it is correct. You show me this letter of the state police headquarters. Sure. No, because they say that it is done. He made a submission that it has been accepted in the petition already. But if that letter you can produce, I think that they do not stand anywhere.
And I'll come back to that.
They do not stand anywhere.
3.1.
Yes, sir.
Here, it is fairly contended that in the bar, that the date, last date of submission of CCR with due acceptance of the property statement has now been extended to 26/9/2025.
That is today.
It is also fairly contended that in the meantime, the petitioners have already submitted their property statement details offline. This offline we have submitted.
Admit, then read the next sentence.
It is accordingly contended that taking into account the extension of the date of submission of CCR to 26/9/25, so made by the state police headquarters by
Letter dated
25/9/25, so produced in the
show us, sir. Produce.
So,
Produce, sir.
this 25/9/25, there is a circular
Please
notification, but
Please
there it is
produce.
not 26. It is
No, sir. 25/9 letter produce.
25/9 letter.
Or any letter produce which extends the period till 26/9.
Yeah, that is,
No problems.
this letter is not there, but
So
that's
you'll have to produce, you have produced before the single bench, not before us. You just produce the letter, he's out of court. There is no difficulty. You then do not stand anywhere. Then you do not.
Wide annexure 1 series, if your lordship will find, I have
Whatever.
produced all the extensions.
If the extension is done, then in that event, if they file a offline, we will know. These are the technical things, online or off. Disclosure of the property statement within the timeline is important. Sure, sir. The letter. You have produced before the single page? You produced before us. Sir, find out. You lose next day. That is the only issue. I think. If you can produce that letter, no issue. They are out of court. They are out of court.
Can it take on Monday?
Whatever, not Monday, then.
Monday, but I will be in the vacation. I will be outside. I am scheduled to go outside. So that is
When you are
on Monday. On 18th, I will be.
Come on Monday. Only thing is that you have taken a stand that it has not been extended beyond February, May. They have taken a stand, it is extended up to 26th of February. If they produce a document, no problem. Yes,
Next.